Do you have the appearance slips? Did they give you that?
I have, yes.
Okay.
Court, all rise, please. Hearing. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Henry. To my left is Judge Desmond. And together we are your panel on the 6 cases we are hearing this morning. I believe you are all veterans to this, so you know the rules. There's 15 minutes per side, no opportunity for rebuttal. Since 15 minutes is generally not a great deal of time, we urge you to the extent possible to cut to the chase. That having been said, and please, in that respect, keep in mind we have read the briefs, we're familiar with the facts and the legal arguments. That said, if there's still time on the clock and you've said everything you want to say, there's no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I'm going to call the first case, which is a case against a juvenile. So we remind the parties not to refer to the juvenile or any other juveniles by name. The case is 2023 P130. Attorney Maloney.
Good morning, Your Honors. Mike Maloney for the appellant. The issue before the court specifically is on July 22nd of 2022, whether a seizure occurred and whether or not my client was unreasonably held without reasonable suspicion prior to Officer Sanchez, prior to his interaction with Officer Sanchez. I point out, as Your Honors are familiar with the fact pattern, but some variables that I find very important to point out specifically, that the shot spotter went off approximately 19 minutes prior to the interaction with Mr. Sanchez. I find that to be strikingly distant in many of the cases cited by my brother, specifically in regards to totality of the circumstances and the facts that were aware to Mr. Sanchez at the time.
So what are those facts? So 19 minutes earlier, the shot spotter went off, right? 4 shots.
Yes, sir.
What would you say the distance was from where they actually end up stopping these fellows over by Calumet?
It was walking distance. It was documented in the police narratives, Your Honor, as approximately a 6-minute walk between the shot spotter and the date of the location of the police cruiser specifically.
So fairly short distance.
Yes, sir.
10 o'clock at night.
Thereabouts, Your Honor. That's accurate.
Shiesty head gear. I'm going to call it headgear, but so that I would say may be reasonable for November, but who's wearing a masked headgear in July?
Fair enough, Your Honor. Thank you very much for that point. I would also point out that Officer Sanchez is not contested. These are not contested in the facts, but it was consistent with other clothing worn by individuals of the appellant's age at the time. The appellant was approximately 15 years old at the time, sir.
That may be true. And then the call was a couple of guys with face masks.
That's accurate, Your Honor. Yes. And
so all that together, coupled with the officer seeing him adjusting the waistband.
If Your Honor were inclined to look at the totality of the circumstances, certainly adjusting the waistband, moving mannerisms with his hands, I would encourage Your Honors to also encourage the totality of the circumstances where the appellant is actually walking up, solicited by Officer Foley, walking up to an unrelated police cruiser, engaging, leaning into the passenger side of the window.
I get it, I do. But we're talking reasonable suspicion, not probable cause, right?
We are, yes, sir.
And so that may cut both ways. I mean, you have a guy who arguably is armed, shots just went off, and he's leaning into the cruiser with a police officer. Safety issue for the officer?
Your Honor, could you repeat that, sir?
Safety issue for the officer?
Safety is always tantamount to law enforcement, Your Honor, but there were no indications at that point, nothing even contested in regards to the operator of the vehicle, the other officer, feeling in jeopardy. Nothing that was provided in the body cam, no interaction, no testimony by Officer Sanchez or other.
Would you agree that Officer Sanchez had more information potentially than the other officer did? He's the one who witnessed the adjusting of the waistband and the mask on his face.
I would agree that Officer Sanchez relayed during testimony that he had information that he saw the appellant adjust his waistband, Your Honor. But standing alone, it's defense's position that that is not enough for reasonable suspicion.
Standing alone, it may very well not be, but it's not standing alone.
Correct, Your Honor. You're not. Approximately 19 minutes earlier, shot spotter indicated that shots were fired. Also, standing alone, there were no incidents of gunfire being reported. There was no sighting of a gun. All these variables, Your Honor, are simply pertinent when Officer Sanchez was approaching the cruiser operated by Officer Foley. The appellant's hands were by his waist. He was wearing clothing consistent with other individuals of his age. Shots had been indicated that had been fired earlier in a very highly populated, dense area.
He was the only one on the street at the time?
Excuse me, sir?
He was the only person on the street at the time. I know they had seen some other folks who were unrelated, or seemingly so, but was he the only person, I think?
There are no facts to indicate that he was the only one standing in the street at the time. There are facts to indicate that other individuals were seen shortly before the interaction with Officer Foley. Sir.
So you say in your brief that that Officer Sanchez's testimony that the suspect was wearing black pants is not supported by any objective or documentary evidence the court has in the record. I didn't understand that. Are you saying there was evidence to the contrary?
Your Honor, forgive me if I'm not understanding your question specifically, but if you're asking me, was there evidence that the appellant was wearing clothing that was not consistent with the description?
Yeah. Well, you know, it's a heading in your brief. You specifically argue something about the objective, that there wasn't you said he didn't match, or the pants didn't match, but there was a report that the people had black pants. I was confused by this.
Your Honor, I would suggest that the report that was issued was sufficiently vague. It was black pants. My client was wearing white sneakers. This was also variables that were not articulated. I understand.
It's on page 22 of your brief. You say that Officer Sanchez's testimony that the subject was wearing black pants is not supported by any objective or documentary evidence the court has before it in the record. So I just don't know what that means. I mean, what are you trying to convey with that statement? Because the radio dispatch was that the two suspects, so somebody had decided two people were suspect, were wearing all black, including black pants. This according to the Commonwealth's brief.
Your Honor, I appreciate that question. I'm not in a position to answer that right now.
Okay. So I think you also argued that the danger to the public safety was not a factor where the shots had been fired 19 minutes earlier. But I guess I'm not understanding that either. Shots were fired and nobody had been apprehended. So do you think the danger had dissipated?
I would agree, yes, the danger had dissipated greatly in the 19 minutes that elapsed. Again, this was a shot spotter, not shots fired.
As you know, the SJC's last pronouncement on juveniles that may have guns in their waistbands is Karen K. Why aren't the facts here a lot stronger for the Commonwealth than in Karen K? There were shots fired in Karen K, but it was the day before.
Your Honor, I appreciate that question. I'm not prepared to answer that question at this time.
So what do you think the officer should have done? What do you think Officer Sanchez should have done, given all that he knew? And we didn't really talk about his familiarity with Calumet Street, the cut-through, the firearms that he's been involved in that area in the past.
Engage. Engage in communication and see if reasonable suspicion arises. The facts are very clear that Officer Sanchez approaches the vehicle driven by Officer Foley from behind. The appellant, my client, is in the passenger side leaning in the window, communicating.
Video, we have the benefit of the video.
Yes, sir. Defense's position that is Officer Sanchez could have easily communicated, asked a question, and thereby escalated the situation to receive reasonable suspicion at that point, sir. Again, this is not someone that was showing signs that he was averse to communicating with police. This was not someone that was fleeing. This was not someone that was showing signs of aggression. Taking into consideration that he had his hands by his waistband and he was moving, this is someone that otherwise was acting like an ordinary 15-year-old boy in that neighborhood, communicating with police and not backing off. That is a variable that I would urge the court, that is a variable that should be taken into consideration. Officer Sanchez, with all his experience, with all his background and training, could have had one question or one just initiated communication and gone from there. If there are no further questions.
Thank you very much. We will
Thank you, Your
hear
Honor.
from the Commonwealth.
Thank you very much. Good morning. Kenneth Steinfeld for the Commonwealth. There are 4 or 5 factual points I'd like to address. First, the officer did testify that there was no one else on Calumet Street at the time he saw the juvenile in the cruiser. He had testified that earlier when he was on Parker Hill Ave, he had seen 2 people, 1 or 2 people who did not fit the description, but that was it. Once he went through the parking lot from Parker Hill Ave up to Calumet, there was no one else on that street. And the only person that he saw, besides the cruiser, was a juvenile who had matched the description, or a person who had matched the description. Secondly, the officer did testify that he thought that the approach by Officer Foley in the cruiser was unsafe. And that was part of his calculus as to why he felt the need to do what he did, because he did not think it was safe for Officer Foley to have driven up and approached him and to have spoken to him, which I think is...
Can you set a stage on that for a little bit? Because
Yes.
I couldn't figure out.
Yes, absolutely.
So I'm very familiar with this area. I couldn't figure out if the youth was walking towards Officer Foley's cruiser or if Officer Foley was coming up while, they were walking and driving in parallel, but the cruiser pulled up.
Well, the testimony is not perfect, but I think that the best way to read it is, and a fair reading is, when Officer Foley walks through the parking lot, he sees the cruiser, and he sees the juvenile walking toward the front of the cruiser on the right side of the street. So he says, when the juvenile saw the cruiser, he made the adjustments both to his mask and his waistband. The juvenile then walked to the passenger side and spoke. The window was down, had some kind of a talk with Officer Foley. But at the beginning, he was walking towards the front of the car, and then he went onto the passenger side. And that's why Officer Sanchez went behind the car, because of the element of surprise.
And I will say this youth was quite a cool customer. I mean, in many of these cases, the perpetrator starts panicking, and it's visible in the video. This guy was literally completely chill, bent over. Do you agree his face was fully visible in the video?
I would not agree that his full face was. Most of it, when we see him in the video, you can see the bottom part of his face, but he may have adjusted. The description by the officer was that only his mouth. But yeah, almost all of his face.
But he's just totally leaned over, chatting with the officer like he doesn't have a care in the world.
Well, but I think it's also would be reasonable to say he was dead to rights. If he had taken off at that point, then he may have thought that he'd have given the officer.
I know, but I mean, we're just, it's an ocean of cases of people who really are not good at being criminals, right? They just panic, or they sweat, or with this guy was just, and he's saying we should take into account that the juvenile was completely relaxed. And the video looks like he was completely relaxed. So does that cancel anything out, or you're like, nope, it doesn't matter at all? It's
Well,
too
I
late. The second that officer sees him touch his waistband. I mean,
Well-
I myself have been very tempted to write a one-sentence dissent in some case to just say, black people cannot touch their waistband
Right, but
in
this-
Boston. They just cannot. They need to walk around with jazz hands the entire time, or they're going to get stopped.
If I may, there's no evidence in this case that it is a race case at all. There's no description of the suspects as to their skin tone, their race. It's not part of the case. The description was the suspects were wearing black clothes. It said nothing about that, and it was not argued below, and it's not supported by the record that the juvenile's race had anything to do with it. I'm not saying that the fact that he did not run and that he actually stood and spoke should be excluded totally from the reasonable suspicion calculus. I'm definitely not saying that. You can take it into account, but I think it's overwhelmed by the other factors, the ski mask in July, the physical proximity to the crime, the fact that if you were to take an indirect route in 6 minutes, it's only 19 minutes, that's not
Right,
much.
but we're all saying ski mask in July, and yet Officer Sanchez did say that this was normal wear for the juveniles, for juveniles in that area. So what are we supposed to do with that?
Well, he said that it was not uncommon to be worn as a mask supplement. This man, I'm sorry, the juvenile did not have any mask, sort of COVID mask on. And I think because it fits the description that was given by the witness who said there were two suspects who were fleeing in black wearing ski masks in July. So I think each of these factors adds up. The officer was aware of that, and there's no one else on the street, and he sees a person on the street wearing black clothes. I also wanted to get to the black pants part of it. He sees that person wearing the ski mask in July, so taken together all of these factors, it's obvious everyone knows that you just don't consider one or any of them standing alone. The description went out to the officer that the suspect was wearing black pants. And the officer testified that when he first saw the suspect approaching the front of the cruiser, when he was walking through the parking lot, he saw that the suspect was wearing black pants. Now, on the video, by the time he gets around the corner and he sees him, you can see on the video that he's wearing black Adidas pants. They're black with 3 white stripes with an Adidas logo. So that it's not just the officer's testimony that he was wearing black pants that was credited by the judge and therefore was a fact, but there was in fact, and I addressed that point specifically that you raised in footnote 13 on page 18 of my brief, how in fact there was documentary evidence, there was objective evidence to the extent that that phrase means anything.
It went out on the radio that they were wearing black pants, right?
Right. And the officer, but the defendant says there was no testimony that this juvenile was in fact wearing black pants. And I'm saying there were two kinds of evidence. There was the testimony by the officer that when he saw me had black pants, that was credited by the judge. And plus the video itself showed that he was wearing black pants. So I really don't understand that argument either. And as I said, it's addressed in footnote 13 of my brief. The black pants was just part of the description that fit.
Well, do we take into account that Officer Foley, who perhaps had less training, it does seem what he was doing was quite dangerous. But he was not at all bothered. He says, actually, on the video, he just says he rolled up on the guy and the guy was just talking to him and he had no idea the guy had a weapon.
But that doesn't exclude the possibility that that Officer Sanchez could reasonably suspect that their opinions may differ. We don't have any information about Officer Foley's experience. And he was not called at the hearing because the defense counsel himself said that that's not part of the case. We're not saying that that was a stop. So the fact that one officer perceived him not to be a threat does not make it unreasonable for the other officer to have perceived him as a threat and to act accordingly. And I think if you watch the videos, obviously the members of the court there's a desperation, there's an air of, as soon as he sees him on the other side, the officer runs as fast as he can to the back to get the element of surprise, and he immediately, and he testified, he thought it was unsafe what Officer Foley had done. So I don't think that you can attribute a whole lot to the actions of Officer Foley in this case, except to the extent that it shows or helps justify why Officer Sanchez was afraid for his safety and for Officer, because he thought that given the information that we had, and has been noted, we don't know what information Officer Foley had about the suspect. We don't know whether he got the same broadcast, the same dispatch about the clothing and the ski mask. We don't know what his information was at that time. They're just not in the record. So he may have been fully justified in not being afraid of the juvenile and just pulling up and starting a casual conversation. And perhaps the juvenile, and I don't want to speculate, but perhaps he sensed that the officer was not, Foley did not see him as a threat, so of course he's going to stop and engage with him. But Officer Sanchez had more information, or had information that we know of, that makes it highly likely, and certainly there's a reasonable suspicion that he was the person that they were looking for. And if the court have no further questions, I'd be happy to rest on my brief.
I have a couple related to
Sure.
your brief. There are two places in which you cite the majority opinion in Karen K. from our court.
Yes.
And in one of those places, you say the SJC affirmed what we did in Karen K. You understand, don't you, that when the SJC grants FAR, it is then reviewing the decision of
course,
the
that is
Superior Court?
Absolutely, I do understand that.
And you understand that the SJC does not affirm decisions of this court even when it comes out the same way?
Yes, of course, it was a poor choice of words. They affirmed the denial of the motion to suppress by the trial court.
So where the SJC has not, as it does about once a decade, incorporate something we said by reference, how is an opinion of this court of any precedential value once the SJC grants FAR?
Well, the points that I cited this case for were general points that I don't think, when this court said in Karen K, the judges should avoid taking a look at each one piecemeal in a granular sense. I think as a general proposition, that's correct, that's accurate. That's not something that is sort of debatable. I don't think that I relied on the majority opinion in Karen K. I think that I relied
twice.
I did, but citing it does not mean that I also cited the SJC's decision in Karen K more often, because that is obviously binding precedent that had the concurrence of all 7 members of the court. So I think that the citations to this court's decision in Karen K were not misleading at all, and I didn't try to imply, or certainly didn't intend to imply, that that was binding. Of course the SJC ruling is, and perhaps I should not have said that the SJC affirmed the appeals court, but beyond that, I think that my citations to this court's decision in Karen K were appropriate. I may go back and look and disagree, but that's how I remember it, and I certainly won't make that mistake.
Well, there are only 2 instances where you can cite an appeals court case after the grant of FAR. One is where they have specifically adopted our reasoning, and the other is if there's a tie vote in the SJC pursuant to, I believe it's Appellate Rule 27.1G. But other than those 2 instances, once they have granted FAR, our opinion is gone.
Well, but I would argue, and perhaps I'm mistaken, that if there is a pearl of wisdom or a nugget or something of general applicability that's stated in,
I thought everything we
this
said
court,
was a pearl of wisdom.
yeah, if I see one, and I thought that the point about granular, taking each at a granular, was a point worth making just because it hadn't been explicitly adopted by the SJC. I don't see why I can't cite that as a general principle, as a good turn of phrase or something that this court can use. I don't believe that there's a requirement that I am barred from citing it for that proposition, even though the SJC has not directly addressed it. I think that would not be a good rule if that were the rule, because if you find something good and useful that the SJC has not contradicted, I think that I should be able to, and have cited it, even though it's been taken on FAR and affirmed, though not explicitly on those grounds. I hope that's addressed Your Honor's question.
Thank you very much. The case is submitted.
Thank you very much.
Thank you. Our second case of the morning is 2022 P699, Commonwealth versus Julio Lima.
May it please the court. Good morning, Your Honors. Jennifer Peterson here today on behalf of Julio Lima.
And if I could remind you, this case is partially impounded and no reference to the victim's name.
Yes, Your Honor. Your Honor, once again, this is a case where the Commonwealth wants to eat its cake and have it too. And I say that because here, the Commonwealth's, the case turned on credibility. And the Commonwealth here intentionally withheld information that was known to it as of after 2 jurors had been impaneled, prior to the jury being jeopardy attaching and the jury being sworn. And the background of the case is the Commonwealth discovered a piece of information saying that there was a pediatric SANE examination that took place, and the evening after 2 jurors had been selected, and reached out to her office. Did not reach out to defense counsel to let defense counsel know. The following morning, during bench conference...
When you say she reached out to her office for what?
Reached out to ask for information about this pediatric SANE.
Specifically, what information?
She asked for a copy of the pediatric SANE.
Well, didn't she ask, did a SANE exam actually occur?
Yes.
Didn't she have some questions about whether or not a SANE exam had taken place, given the distance and time from the exam and the reported rape?
Yes.
Okay.
But I would suggest that...
So she hadn't had any confirmation at that point. Why would she reach out to the other side?
The email, I believe the email suggested that it had taken place, that it did exist. She made a conclusion based on her own interpretation of why would that happen? Why would 8 years after that there be a pediatric SANE? But
Do you think that's a fair question?
Whether or not it's a fair question doesn't really...
I'm asking, do you think it's a fair question?
I think it's a question. I don't think it's a fair enough question to not contact defense counsel and say this issue exists, to not disclose to the court the next morning before jeopardy attaches, before the jury is impaneled, especially in light of the fact that the next morning there was a conference about the judge had some conflicts. There were issues with whether or not interpreters could be...
Let's say we agree with you, and in fact, I've seen this case before, only it was with a scheduling question with the witness, but we said, omitting the word scheduling, and I'm quoting, that the prosecutor should not have kept this important, in that case scheduling, but in this case a different kind of information about the case to herself, and arrogantly or foolishly hoping, the issue would go away and would, she just essentially disrupted the trial judge's ability to manage the courtroom and the trial, and this was not consistent with her obligation to the court or defense counsel, okay? And even if we assume that is true here, and you certainly have some force to your argument, the Commonwealth argues that in the case Commonwealth versus Lamhue 2, that the Supreme Judicial Court held that delayed disclosure of potentially exculpatory evidence is not sufficient to invoke the double jeopardy bar to the further prosecution. So how do you distinguish that case?
I would distinguish that case because I think, what the SJC seems to be saying is that it depends on the facts of the case and the intentionality. And I think here, this case shows an intent to withhold. And the prosecutor even says that, she understands why there would be a mistrial if the evidence comes back in a way that indicates...
But that takes you back to Judge Desmond's question. I mean, she was definitely foolish, I would say. And I really hope that this DA's office and all DA's offices say that prosecutors should treat this information like a hot potato. They should share it immediately with the judge and the defense counsel. It is, in my opinion, very bad not to, and it really wasn't good here. But, Judge Desmond's pointing out, well, it doesn't make any sense to do a physical examination 8 years after an alleged sexual assault. So it doesn't seem crazy for her to say, this doesn't make sense, and let me just explore this.
Essentially then, if we allow that interpretation, what we're doing is we're allowing the Commonwealth to act as gatekeeper and the Commonwealth to make these decisions. This isn't the Commonwealth's province. Whether or not this is going to, come up with important exculpatory information is something defense counsel gets to know, and the Commonwealth doesn't. The Commonwealth has been in a position of being gatekeeper, and things haven't turned out so well for defendants. And this is a situation.
Or justice, one might argue.
If we allow this kind of behavior and say that there's not a lack of intent because the DA had good intentions or a good reason or whatever, then essentially we're encouraging this type of withholding behavior until, the evidence supposedly proves beyond a reasonable doubt.
But I think that SJC is saying that there's a bigger consideration here, even if this behavior is very troubling, which is that possibly a crime was committed and that the public has an interest in seeing the defendant tried for that.
That's true, but the public also has a very strong interest in constitutional rights of the defendant and the right to be able to defend yourself, and especially in a case
Right, so the balance is that the mistrial is granted and then the defendant has the information and time to develop defenses based on it, and then we try the case, and that's what happened here.
Well, I would suggest that even if the case came down that way, there are more issues in this particular case. And all of these issues, I would just say, to frame it all, defense counsel was very consistent about making objections, and all of the arguments raised are
Defense counsel should be commended. No doubt it's, the defense counsel made their record, and that, is what they're supposed to do.
As a practical matter, what is the exculpatory value of this piece of evidence?
Well, I think as far as the exculpatory value, this whole case turned on the credibility of the witness, and this particular piece of evidence is a preliminary matter. It raises a question, like Justice Desmond said, why, after all this period of time, did they do this? And the question it would raise to me, 8 years later, there's heavy DCF involvement with this family, not related to this issue at all. Heavy involvement. Was there a different issue that was involved at that time? There's reference to...
What if there was? How does that bear on this case?
Because I would suggest that there may be reasons why these accusations were brought and when they were brought. These were supposedly took place in 2006. This trial is happening in 2021. So, jurors are necessarily going to have a question, what happened in those intervening years? And how credible is this? And why did this complaint arise when the complaint arose?
Why does it matter what happened in the intervening years?
I think it matters significantly in the juror's mind because...
Okay, go ahead, I'm sorry.
Because there could be other issues, there could be other abuse. He was out of the house for 4 years at that point before any allegations even arose, or, excuse me, I believe it was 4 years, before the allegations arose. And there was, this child had behavioral issues at school. The child had counseling for other issues, and so defense counsel theoretically could look through all of the different counseling records and go a little bit...
Maybe they did, for all we know. She may have... we can speculate. Mm-hmm. We can speculate that a child who's raped by their stepfather may have behavioral issues at school.
Well, there's a lot of speculation that can be done, which is what the Commonwealth did, what the DA did, is she speculated. And she speculated, and defendant was not allowed to go and actually do the research. And I would suggest if you look at this case...
When you say the defendant wasn't allowed to go to do the research, what are you pointing to? I'm sorry.
Oh, the fact that they withheld the information that there had been this pediatric stain, and the notes to the pediatric stain, had information in it that suggested, that there was counseling, that the first complaint witness wasn't the first complaint witness, that the first complaint witness was actually the brother.
Do you think that, as you stand here right now, do you think that this prosecutor intentionally withheld that information to bolster her case? Is that what I hear you saying?
I think the prosecutor intentionally withheld it to hedge her bets. I think she wanted that first complaint witness to testify.
She stipulated that there was no finding, right? She was prepared to stipulate to no finding of any evidentiary value as to this defendant.
She was willing to stipulate to it after the jury was impaneled, after the complainant had already testified and was crossed, and prior to bringing on the first complaint witness, who wasn't actually the first complaint witness. So defense counsel couldn't even say in opening statement, hey, there was a PD saying there's absolutely no evidence of assault. He was precluded from researching it to see if there were counseling records, to see if there was other problems that were happening in the household that would warrant, why is it she would raise these particular issues? He couldn't argue it in opening. He couldn't cross-examine her about the pediatric saying or the statements that she made.
But I don't understand, because you had a mistrial, and the Commonwealth argues that you're claiming the records were crucial and critical, but defense counsel never used them in the second trial. So did the defendant use the records in the second trial?
Well, as a preliminary matter, I would say that that's not the standard. It has to do with whether or not there was an intentional withholding, whether she intentionally
Right, but we have okay, but let's break it down.
Okay.
I understand your point, very fair point, that we're just judging at the moment in time. But did the defendant use the records in the trial?
The defendant didn't use those records, but the Commonwealth said it wasn't going to call a first complaint witness, presumably because the first complaint witness, the sister who they called at the mistrial, wasn't available. We don't know why.
Right.
But she wasn't the first complaint witness, according to this information. And so that wasn't used, and they said that they weren't going to call any first complaint witness. So there would be no need to raise these issues, because it could just open a Pandora's box. And I'm not here to speculate as to why trial counsel, strategized the way trial counsel strategized.
All right, so going back then to the moment in time when the judge makes the ruling that you're appealing from, then what I don't understand how the prosecutor's behavior would have helped the prosecutor. It seems detrimental to her.
I don't think it's detrimental. I think what she did is she controlled how things came out. She made a decision. She even said, well, then we can just stipulate to this part of it. She controlled whether or not this information could be put to the jurors. She had exactly what she wanted. This is why I said the Commonwealth wants to eat its cake and have it too. If the trial goes according to how the Commonwealth is hoping it's going and going well, then we can just leave, bygones be bygones. But if it doesn't, then she can say, of course defense counsel made it really clear he thought a mistrial was appropriate, and she knew that, and she even says it. And I think on the mistrial, volume 2, 165, I understand why there would be a mistrial. She knew at that point why there would be a mistrial, and she's hedging her bets, and that's just fundamentally unfair.
So I'm sorry, I'm just trying to follow the argument, so just help me one more time. How is it that she's hedging her bet?
How is it?
In the light most favorable to the Commonwealth, how is this evidence helpful to them?
How is the evidence, I'm sorry, Your Honor?
Helpful to them?
Helpful to them?
Yeah.
The evidence of the same?
Yes. Why would she hedge her bet? What I don't understand. I don't follow that argument.
This is mandatory discovery that should have come out, and she's hedging her bets because...
We all agree with that, I think.
Okay, because there's information in there that would blow up her case, which is that
That's where you lose me. So tell me how that information in there
Because
of a sane exam that was taken 8 years after the alleged rape. How would that blow up her case?
it wasn't just the fact of the SANE exam, which showed that there was no sexual abuse, which resulted in nothing.
But whatever that's worth, 8
Oh,
years later.
well, defense counsel could have used that and said
But
there's no...
didn't in the second trial.
But, okay. But that's neither here nor there.
Yeah,
Okay.
But you can't say they could have used it, and then we had a trial where they
Because then
didn't use it.
but then defense counsel would open the door to perhaps statements and the like that were made at the same time.
That's the risk.
And that's defense counsel's strategy. The question that we're focusing on here is, does the DA get to control defense counsel's strategy and how he's defending his client and keeping this information? And I'm running out of time, but with respect to the whole first complaint issue, notably, the deliberating jurors asked for Detective Cotto's report. They wanted that detective's report. There was nothing there that said anything about urination or touching or any of these things. And, you know, you ended up with all of these different first complaint things that they called not first complaint, but the judge seemed to misapprehend what first complaint was. And they allowed the rebuttal witness to come in and rebut, essentially boost the complainant's, credibility, because there's nothing there. Why would there be such a delay?
Counsel, I'm afraid you're
Okay.
out of time. Thank you very
Your Honors.
much.
I would rest on my brief with respect to the rest of it.
Thank you.
Good morning. May it please your honors. My name is Rob Kidd. I represent the Commonwealth in this matter. Starting out with the first issue, which is the non-disclosure of this information, I just wanted to first direct the court to the applicable law, which is clear. And the law says, the phrase is goading, and I don't think counsel uses that. The phrase that the law talks
Well,
about...
could we just start with the preliminary question, which is, what the heck? I mean, do you train your people that they need to disclose this? I mean, they were in impanelment, for heaven's sakes.
I understand.
I mean, this was actually not good for you either. Like, this seemed like this person didn't know what they were doing.
Yes, I mean, I can't speak to the training, but in looking at it, it is something that in better practice would have been for the prosecutor to immediately disclose that as soon as she walked into the courtroom. I agree with the court.
I know, but so why should the courts keep excusing non-disclosure? Like, what message, when is the message going to get through? I mean, we've had case after case, I mean, spectacular, awful cases where the prosecutor didn't disclose what they should disclose. And, I mean, where the courts have imposed some drastic remedies. So I just don't understand what's going to get through.
I understand. In fairness to the prosecutor, though, as we know, as to Judge Desmond's point, 8 years had gone by since the...
No, she took the most optimistic view, no doubt about, like,
I'm sorry I interrupted, but she was the third prosecutor on the case. There were two before her who apparently didn't get the exam either. I'm not...
Which is why I'm raising the training question to begin with. Like, I mean, I hope you get a message that you should go back and say, we have a training problem and we need to fix it.
Yes.
But your point, I take it, is that there was a sanction here. It's called a mistrial. And the issue before us is not whether a mistrial was justified, but whether or not there was the attachment of double jeopardy.
Yes.
And that issue turns on goading.
Yes. Yes. And as far as the defendant being prejudiced by this late disclosure, as counsel was saying that, defendant couldn't investigate these records and couldn't use the prior inconsistent statement and so forth regarding who the first complaint was, Your Honors, she got the remedy the defendant got the remedy that he was entitled to. He got a new trial in which he had all the time in the world to go get those records, and which he attempted to do. As we know,
I take it, but there's no dispute that the prosecutor withheld this, during further impanelment, during a morning conference, as the jury was sworn, during opening statements, during the examination of the plaintiff, right?
of the first complaint.
You agree with those facts, right? There's not a fact, okay. And I couldn't get, really frankly, from either one of your briefs, but I was expecting it from your brief. Can you give us some examples of what would be goading? Like, where are there any cases
I
where
don't know that
we've?
there are, I don't know that there are any. I did put the,
Yeah, well, that
obviously,
concerns me, right? Because if we say, okay, well, the standard is goading, but then we never find goading, what are we doing?
well, I can tell you, Your Honor, what isn't goading. Well, I can tell you what isn't goading, and
That'd be
there's a
helpful.
couple of cases that I cite in my brief, Your Honor. As we know, Lam Hugh Toe said told us that inept bungling by the prosecutor or the police is not goading. And in Lam Hugh Toe, I suggest the facts were more egregious. You had a police officer who apparently sat on a knife, an extra knife that he found at a murder scene, and he didn't tell anybody until the middle of the trial when he was cross-examined by the defense counsel. And defense counsel immediately moved for a mistrial, or he immediately moved for a hearing, and then a mistrial. And the court said that, that sort of negligence is not enough. The phrase is specific intent. You have to have specific intent to goad. And that's a case that I cite in my brief on page.
So is that a situation then where the case is perhaps not going well for the prosecution, and so they're trying to throw the game?
Yes, that's the whole idea, exactly. The whole idea is that, you're trying to throw the case, which obviously is highly unethical. And I don't, that was not the case here.
Did the, I'm sorry.
Go ahead, Your Honor.
Did the prosecutor argue against mistrial?
Yes, she did, yes.
So help me understand the wisdom in goading for a mistrial, getting the defendant to move for mistrial, and then arguing against the mistrial.
Well, this is what I did say, exactly what Your Honor said in my brief. There's no evidence that it doesn't make any sense. It doesn't make any sense. And the other thing is, when you think about goading, when you think of the specific intent, think about it. She's got this letter, this email that suggests there may be a report out there. In order to do this goading, she would have to say, aha, I know that there's going to be information that's going to help the defendant, and I'm going to wait for all through the trial, all morning. And then when that information, I know what it's going to be. It's going to be, prior inconsistent statements, and there's going to be medical psych records they can get. I'm going to wait, and then when I get them, I'm going to spring it on counsel. It makes no sense. She's not clairvoyant. She had no reason at that point in the terms of goading. She had no reason when she saw that email to suspect that these records would contain anything other than no finding of sexual abuse.
I agree with you that case is very favorable, but you write in your brief on page 26, it's understandable that she should try to confirm such an exam had been done before discussing it with counsel and with the judge, and that is exactly what is wrong here. I mean, you're in impanelment, for heaven's sakes.
I understand.
At that point, it is not the prosecutor to be like, well, I'm just going to wait over here.
It's true. I do point out in my brief, though, in fairness to her, but defense counsel at the hearing on the motion to suppress, he himself was asked by the judge, did you ever ask yourself for this same exam? And he said, no, Your Honor, I had no reason to suspect there would be an exam because 7 years passed. So he had the same view as the prosecutor. So I know it's not an excuse. I understand, Your Honor. It's something that we will talk to her about, yeah.
I mean, to her and all the other prosecutors, I mean, to be
Yes.
clear, it's information that should have been turned over. You don't dispute that, right?
No.
Okay.
Right. There's two other issues in the brief. It seems like we've talked about the first one.
Would you
I don't.
address
so
the
the-
first complaint?
Yeah.
Yes. All right. So the first complaint issue, it seems like the thrust of that was this conversation that came in. And there was a conversation in which there was a conversation with mother and the child and the father, in which mother basically makes an accusation to the defendant that he did something which implies that mother was told about the abuse by somebody, which very obliquely, very, backdoor suggests that she was told by somebody of the abuse. And then father makes this threat. He says, if you keep that up, I'm going to leave and you're not going to have me. And there's testimony by mother that made her afraid, and that was one of the reasons why she didn't disclose the abuse. As I said in my brief, that conversation was admissible. The defendant's reply to that was admissible as a statement of a party opponent, and it was also admissible and relevant to show why mother didn't go to the authorities with this, because this man who was living with her and her child was going to leave, and she didn't want that to happen. She was intimidated by that.
Assuming we agree with you about that, why shouldn't the judge have given the first complaint instruction?
Well, she shouldn't. Well, well, first of all, first complaint evidence, as we know, is admissible for other purposes. So, yes, I don't know that it was offered here for first complaint, is what I'm trying to say.
Well, it seems like the prosecutor was saying, I'm not offering it as first complaint, but it inherent, I mean, unless the mother just randomly said, are you sexually abusing this kid, inherent in the question was that there had been a complaint. And so the judge could have given an instruction to the jury about that.
I understand that point, but now I'm thinking that through, Your Honor, and I don't think that would have helped the defendant at all for the judge to highlight this very, very oblique backdoor reference to a possible first complaint. And because we know what that instruction is, it's a long instruction that draws the jury's attention to the complaint and said, this is for, you can use this for corroboration. I think it's corroboration of what the victim said and everything. And that was not the intent of this. So, I don't think that would have been appropriate.
So the intent was what, just getting his words in?
Getting his words in, and then justifying and explaining to the jury why mother didn't disclose these events immediately, because she didn't want to lose the defendant. He was going to, originally it was going to be coming in as the defendant was going to take the children, but the way it came in is he said, I'm going to leave you all here. I'm going to leave. And mother testified the reason she didn't disclose was because she was intimidated by the fact that the defendant was threatening to leave. So that explains the delay in disclosure, which is very common in these cases, as we know.
And then the second statement where the mother gets back on the stand and in rebuttal gives the testimony she gave, and that's admissible as a prior consistent statement of the victim?
Yes, because counsel made a big deal or brought out through a police officer that this victim's statement about ejaculation, that she never made this statement about the defendant ejaculating in her SANE interview, and the police officer testified to that. He didn't remember her saying that, and it left the jury with the impression that this was a recently contrived testimony, that she went on the stand and testified to this. It was not. The prosecutor
was the SANE interview not recorded?
Yes.
Yes.
It was recorded. It didn't go into evidence, or it wouldn't usually go into evidence. I don't think it did.
Well, no, but you have, I mean, it's this weird situation where you're asking the officer what he remembered.
Yes. I mean, the other way counsel could have done it and would be to just play a well, it's a tough one because counsel would have had to prove the absence of a statement, then he would have to play the entire SANE interview if he's trying to impeach.
No, he wasn't going to do that. I agree with you.
No, so that's why I think it was brought out the way it was. Right. If there's no questions, I'll rest.
Thank you very much. The case is submitted.
Thank you, Your Honors.
Our third case, and the last one before we take a brief mid-morning break, is Commonwealth versus CARINO, 2023 P914. And I would remind the parties again that this is partially impounded. Please, no references to the name of the victim. Counsel, could we begin with an important housekeeping matter with reference to what is in the record appendix? If you go to record appendix page 12, you have a black and white aerial photo marked Exhibit 2, and you go to the next page, there's a color photo which appears to be identical, except it's in color and you can see more. Since the first has an exhibit tag on it, I assume that's a black and white of what was in the court, of a color copy in the court, and then what appears as a color copy is just from someone's files because they had easy access. But then I get very confused when I go to the next page, which is Exhibit 4, which is a black and white street photo. And then the next page, without an exhibit tag, is a color photo. And I assumed when I first looked at these that these were the same photo, but in fact they're not. One's from the left side of the house, the other's from the right side of the house, and I have no idea whether the color photo that appears, I believe it's page 15, was part of Exhibit 4 or not. The references to Exhibit 4 in the transcript seem to speak in the singular. Can you shed any light on this?
Thank you, Your Honor. And for the record, Rachel Chana on behalf of the appellant, Mr. Carino. I do believe better practice on my part would have been to get color copies directly from the trial court. However, I got black and white copies from the trial court and produced the copies from the trial court in the record appendix.
I understand with regard to Exhibit 2, but could you talk to Exhibit 4?
I don't have an explanation for that, Your Honor.
Well, do you know if the color photo appearing at Record Appendix 15 was in fact part of Exhibit 4?
What I
mean,
was
the
told-
Commonwealth essentially relies on this photograph. That's why
Right,
I'm pressing
right.
the issue.
Right. So what I was told was that the color copies are a reproduction of what the jury saw. I don't have an explanation for why they are slightly different.
Well, I mean, they're not just slightly different. One's from a different side of the house. Any event,
Right.
please proceed.
Thank you, Your Honor. I do think it was important to produce, obviously, the photos that have the stamp of the exhibit on it, not only because it was the trial record, but because these document where Mr. Carino in fact stood, specifically under the sticker of Exhibit 2. This was transcript 166 and transcript 181.
But where in either, on page 14 or page 15, is there a sticker showing where he stood?
There is no sticker on Exhibit 4 at Record Appendix 14 to 15. The sticker is on Exhibit 2 at Record Appendix 12 to 13, marking where he stood on the sidewalk in front of I'm sorry.
So if we're looking at that, I see he was on Crescent Hill, is that right? Which street was he on?
I believe that the particular addresses are impounded and not public information, but he was standing in front of a property with a backyard abutting the protected
No,
property.
I understand that. What I'm
Yeah.
trying to figure out is what I should be looking at on exhibit, well, I'm not going to exhibit the color version of Exhibit 2. So,
It would be this corner here.
okay.
106, is that what that says?
Yes, Your Honor. And so the prosecution was required to,
106 represents what? Which
That-
house?
the address in front of where Mr. Carino was arrested,
But
So
looking,
not the, I'm going to call it victim.
not the
collateral.
protected property, Your
Not the
Honor.
protected property.
That's correct. He was arrested on the sidewalk in front of this house that had a backyard abutting the backyard of the protected property, separated
Right,
by
but I
trees.
think-
Sidewalk or in the driveway?
On the sidewalk, Your Honor.
when you look at 106, on the left is a driveway that's made of little stones, and on the right is a completely paved driveway. Was he standing on near the little stones, or was he standing on the asphalt driveway?
The testimony, as I recall it, and again, Your Honors can refer back to transcript 181, testimony by Officer John Costa, and transcript 166, testimony by Lieutenant Gallagher as to where Mr. Carino actually stood. By the time one officer arrived on the scene, Mr. Carino had been taken off of the sidewalk and was on the street. Another officer testified that he was standing on the sidewalk. There was no testimony that he entered the property that had a backyard abutting the protected property, nor was there any...
What were his instructions? His instructions were what?
Whose instructions, Your Honor?
What was the defendant prohibited from doing?
Mr. Carino was prosecuted for a stay-away violation. He was prohibited from contacting or abusing the plaintiff. He was prohibited from coming within 100 yards of her person, and he was required to stay an unspecified distance away from her apartment building. And so this court applies its standard from Watson, Telsonord.
He was charged with, he was informed that he had to stay away from her apartment building.
An unspecified distance, that's correct, Your Honor.
Okay. And so he's at the house behind her house. Just in common sense terms, do you think that's staying away?
I don't think it's common sense, Your Honor, that from where he stood, he could have actually contacted or abused her.
That's not my question. My question is, from where he stood, by him going to that location, do you think that common sense-wise is staying away? Is that in the spirit of this order, do you think?
I think it's approaching the line, Your Honor, but I don't believe it's crossing it. I believe that it's
So you would say, yes, he is staying away. You would say by positioning himself at the house behind hers, in the building, because it's also 7 and 8, that he is staying away. You would say that.
I would say that he's in the vicinity of the protected property.
Do you think that that's staying away?
According
by
to,
positioning yourself in the vicinity of the protected property is staying away?
according to O'Shea, it is.
I'm not asking you according to, I'm saying common sense. Do you think it's staying away?
I don't think Mr. Carino should have approached the vicinity of the protected property. However, I do not believe that the Commonwealth proved that from where he actually stood, he could in fact have contacted or abused the plaintiff if she were on the property or entering or leaving it.
And do you think that that was because the police stopped him before he positioned himself in such a place? Or do you think that he just wasn't smart enough to position himself in such a place? Because we know that's what he went there for. We know that, right? We know he went there so he could see if she was home.
I don't believe that Mr. Carino's post-arrest statement of what he hoped or planned to do can supply the evidence otherwise lacking from the Commonwealth's
I know, but we know that though, right? But we do know it, right? We know why he went there because he told us. Is that fair to say?
If that explanation is credited, yes.
Okay. And so, do you think that that's staying away?
I do not believe that Mr. Carino can be prosecuted for what he hoped or planned to do. I believe what he may have done, had he not been arrested, is not an element of the Commonwealth's case. Could he be prosecuted for attempt to violate a stay-away provision? That's a different question.
So you think he stayed away? Is that what I hear you say? You think he stayed away?
Your Honor, I believe he entered the vicinity, but I
Okay.
do not believe he stayed away as specifically defined as a legal term by this court in 2018 in Watson, Telsonord, and Goldman.
So arguably, he was able to see through the driveway to the house behind, right?
No, Your Honor, I do not
Look at the
believe the
picture, I could
evidence.
see. Okay, hold on, let's
Excuse
look at
me?
the picture that's in evidence. So when I look at Exhibit 4, that's the only colored one we have, or Exhibit, the colored version, I assume, of Exhibit 4. Is that what this is? Page
The photo
15,
to
on
the
page
right,
15?
the photo to the right of the property in front of which Mr. Carino stood, Your Honor?
On page 15 of the appendix.
Yes.
And with the red arrow, that shows her house, is that right?
No, Your Honor.
What
That's
does the
point-
red arrow show?
I believe that red arrow is pointing in the direction of her backyard. Officer John Costa testified at trial that there was a property in
That's the
addition.
shed?
I believe so, Your Honor.
Well, I
So,
mean, it says right on that the red arrow is pointed toward the back of the home. It doesn't say shed. But again, I don't know that this was an exhibit, like I think the parties might need to tell us.
In any event, the residence was a multifamily house, correct? There was more than one unit.
That's correct,
So
Your
we
Honor.
don't know that this is in fact even her window.
That's correct, Your Honor. There was no evidence that her apartment even included a window into the backyard or was rear-facing, nor was there any.
But her number is number 2, so unless this was a Philadelphia-style two-family, then you could, I mean, it's much easier to see it from the street behind.
doesn't the stay away instruct him to, if this box is checked, the court also orders you to immediately leave and to remain away from the entire apartment building or other multiple family dwelling, not just her unit, right?
That's correct, Your Honor. That's correct. The entire property, not just her specific unit, he was required to stay away from. And I believe what distinguishes this case from O'Shea are the two different post-arrest statements that the two defendants made. In O'Shea, the defendant, after he was arrested, told the police officers that he went to a bank 30 to 45 minutes out of his neighborhood where he spied on the parking lot where the plaintiff parked, where she was working, noticed that her car was not there, and left. Mr. Carino similarly entered the vicinity of where this protected property was located,
Intentionally.
as did Mr. O'Shea. The jury did not credit Mr. O'Shea's post-arrest statement, and this court's resulting opinion focused exclusively on the location in which Mr. O'Shea stood and what he could in fact do from there.
But had
Similar-
she been home, he would have been within the 100 yards, right?
Had the plaintiff been home, then this would have been a different case in which Mr. Carino could have perhaps been prosecuted for a distance violation. In fact, there was testimony by Lieutenant Gallagher that he believed he was arresting Mr. Carino on a distance violation. He was mistaken. And so the Commonwealth pivoted to then prosecute Mr. Carino for a stay-away violation. However, the Commonwealth presented its case at trial as if it were a distance violation and put in no evidence of the elements of a stay-away violation as defined by this court in Watson, Telsonord, and Goldman.
With the possible exception of this photograph.
With the possible exception of, well, Exhibit 2 was the photo that was introduced by the Commonwealth, the exhibit that shows trees taller than both three-story residences and thick July foliage at the time.
So Exhibit 4 came in as a defense exhibit?
Exhibit 4 was a defense exhibit, Your Honor. Exhibit 2 was a Commonwealth exhibit.
So the jurors had Exhibit 4.
Excuse me?
So the jurors had Exhibit 4.
So the jurors had Exhibit 4, Your Honor.
Was there a motion for a required finding at the close of the Commonwealth's case?
There was, Your Honor. There was, renewed at the close. And so I see my time is up, so I would just say.
You may complete the sentence.
Thank you, Your Honor. A plausible hypothesis of guilt is simply no substitute for a finding beyond a reasonable doubt. Thank you very much.
Thank you very much. We'll hear from the Commonwealth.
Thank you, Your Honors, and may it please the Court. Patrick Cespedes from Middlesex on behalf of the Commonwealth. I'd like to start with Record Appendix 15 to hopefully provide some clarity. The defendant included this image among the trial exhibits and cited to it numerous times in his brief. The Commonwealth thus understood this to be part of the record. However, upon viewing the exhibit list in the trial court, it appears that was not the case. This was not included as an exhibit. That would be Record Appendix 15 with the arrow pointing to the back of the victim's house. Per Appellate Procedure Rule 18, because this was not relevant to any issue on appeal nor included as an exhibit, shouldn't have been a part of the record appendix, but even without it, the Commonwealth maintains that there was still sufficient evidence for this to go to a jury.
Okay, so just to clarify.
Sure.
The color photograph appearing at Record Appendix 15, you're saying was never admitted at trial?
Correct.
What about page 14, which has an exhibit sticker on it?
That's correct. That was admitted as Exhibit 4.
But that was a defense exhibit?
Defense exhibit.
Okay, so assuming all that to be the case, then you can't rely on either of these two photos, correct?
We can rely on Exhibit 4, but not Record Appendix 15.
Well, if we're evaluating the evidence at the close of the Commonwealth's case, 4 wasn't in there, right?
Sure. Fair point. The Commonwealth will not rely on that in the argument, but even without Exhibit 4, which doesn't help us that much regardless, plenty of evidence for this to go to a jury, and I'm happy to expand on that.
Please.
Happy to expand on that.
Expand away.
Sure. So first piece of evidence, obviously the officers testified that the defendant was apprehended roughly 200 feet from the victim's residence. Now there's this question of, was he on the sidewalk, was he in the driveway? On page 166 of transcript 1, Officer Gallagher observed that he was on the corner of the lot line and the street, the sidewalk, and driveway, sort of generally in that area. Lieutenant Gallagher had actually observed the defendant park several streets away from the victim's residence, after which the defendant strategically walked sort of parallel to the victim's residence. So we have the 200 feet away. We have the aerial image on Exhibit 2 that shows the proximity of the houses and the sort of smattering of trees that are in between them.
Now, you used the word smattering in your brief. I confess, when I'm looking at the aerial photo in color on page 13, doesn't look like a smattering to me.
I think there's 3 or 4 trees there, but there's nothing to say, maybe I'll rephrase, there's nothing to show that these were sort of impenetrable forest. And in fact...
But it's not their burden. It's the Commonwealth's burden to show that where he was specifically standing on Crescent Hill, he could have abused her.
Right, and I think this takes us right into the defendant's statements to police. Obviously, this is not a specific intent crime, and nor is the Commonwealth arguing that it is. What the defendant's statements to police allow the jury to do is to make reasonable inferences about the defendant's positioning as well as the characteristics of the property itself. So the defendant intends to go to a position from which he can view the victim.
That is clear, and he was stopped in progress.
Actually, the testimony is that when Officer Costa arrived, he witnessed the defendant standing already stopped at the property. And so the jury, it's a fair inference for the jury to make that the defendant stopped where he was able to accomplish his goal. He's familiar with the victim's residence. He didn't go in front of the house. He didn't go to the sides of the house. He stopped directly behind it. One other thing I would note is that the backyard is part of the residence. Now, none of the officers were able to say exactly where the defendant was standing, how far it was between there and the backyard, but they were able to say that he was standing approximately 200 feet from the victim's residence. So logically, the jury is allowed to infer that the backyard is even closer. And the defendant, in his interview, says, I was looking out for the child, who again is part of this APO. I was looking to see if her child, the victim's child, was there, because if the victim's child was in the backyard, I'd know that she was there. And so the jury is allowed to take all of this and say, look, this guy's trying to get a view of his ex-wife, and he goes 200 feet from the house, he stops where he wants to stop, and this is a clear violation of the APO because there's that potential for contact. If he can see her, she can see him.
So he parks his car further away, and then
Further
he
away.
walks closer to the vicinity of the house.
Correct.
Why would the police follow him to begin with?
So, Your Honor, the only thing that came into the record was that Lieutenant Gallagher had a feeling that he would be going somewhere that he wasn't supposed to go.
They'd had a meeting, right?
I'm sorry?
They had a meeting, had the,
So, this was not on the record, but just to give context, he went to the police station to pick up some property. When he was leaving the police station, Lieutenant Gallagher had a suspicion that he was going to go to his ex-wife's house, and therefore followed him. All the jury heard, though, was that Lieutenant Gallagher noticed the defendant getting into his truck and had a suspicion he was going somewhere he wasn't supposed to go, and followed him from there.
In an unmarked cruiser.
In an unmarked cruiser. If I may make one more point, Your Honors, I'd point this court's attention to Commonwealth v. Colpitts, an unpublished 2016 opinion. There the court writes that although the harassment prevention order did not specify the distance that the defendant must stay away from the victim's residence, the defendant should have stayed at least 100 yards away from it because he could not be within 100 yards of the victim. This is a good rule of thumb, especially when it comes to residences, as people spend significant amount of time, if not most of their time there. Defendants should not be rewarded for rolling the dice on whether or not their victims will be home.
So why don't judges include a distance requirement?
Because I think it matters about the circumstances of the case. Now, if the judge were to include a 100 yards away in the thick, dense Boston area, someone may not be able to get to work. Now, out in Western Mass, that distance might be a little bit farther where the houses are spaced further apart. So I think putting a 100-yard or 50-yard, it has to be able to change based on the circumstances. I think that's why the stay-away order is still a very viable option for
But
judges to
when the
specify.
judge issues one of these, they presumably know the circumstances.
Sure, but those circumstances change over time. Imagine, the victim moves, and these things they're fluid, they change, and I think it still gives the defendant clear notice about what he should or should not be doing. And again, we don't want defendants to be keeping a schedule of the victim's movements. So this, as this court put in Telkenord, the purpose of the APO is to create a safe haven for victims from the threat of continued abuse, and the defendant simply undermined that purpose here.
so, but she relies on I think we had 3 cases that all got released together, but.
Yes.
So why is Watson and those other 2 cases, why are they distinguishable?
So in those cases, specifically Watson, so these are the cases that establish a sufficiently near standard. So this sort of third prong of the test to whether the APO is violated. Was the defendant sufficiently near the victim's residence as to violate the stay-away order, and that's sufficiently near as to contact or abuse the victim were she at home or entering or leaving the home. So these cases give various sort of circumstances where this has occurred. This case simply provides another reason to suspect that there was potential contact. And I view these cases, these trio of cases, as simply establishing the standard.
But in at least 2 of those cases, the defendant was standing on the sidewalk directly by the entrance to the building.
Sure. I think in this case, a good case to look at is Commonwealth v. Tate, which is cited in the brief. But essentially, in that case, the court determines that a defendant simply looking down at a victim from the top of a street, just looking, not doing anything else, not waving, just looking at the top of the street, is enough to constitute a violation under this standard. And so when you sort of have the potential for contact, would be able to contact, Tate says that just being able, having a line of sight. And then you have another case, I believe it's part of the trio, though I could be mistaken about that, Haben Strait.
That's an earlier case.
Sure, 2003, but that case goes to say that even if someone would be in the distance of a shouting distance, could constitute a violation of the APO. Obviously, this law, the law does not criminalize accident, mistake, or otherwise innocent conduct. But if a defendant is seen and wants to be seen, or if the defendant comes close enough to be in shouting distance, he can contact the victim. Were she at home? And again, rolling the dice as to whether or not the victim is home is not something that should be encouraged. If there are no further questions, the Commonwealth will rest on its brief.
Thank you both very much. The case is submitted. We are going to take a brief mid-morning break. We will be back with the Perry case a little after 11 o'clock.
Court all rise, please. Court is now in recess. All rise, please. Court is now in session. Please be seated.
Thank you all for your patience. We are back on the record in our fourth case of the morning, 2023 P345 Oliver Perry versus Registry of Motor Vehicles.
May it please the court. My name is George Gormley, and I represent Mr. Perry. Mr. Perry seeks the reversal of a decision of the Registrar of Motor Vehicles that was affirmed by the Board of Motor Vehicle Appeals, forfeiting his CDL license for lifetime. The facts underlying this are begin most recently on December 10th, 2018, when Mr. Perry was arrested operating his personal vehicle and not a commercial vehicle, that for the crime of driving under the influence of alcohol.
How does it make a difference that it was a personal vehicle and not a commercial vehicle?
Well,
under the statute.
It doesn't make a difference under the statute. Seeing as there is, I mention it only because there seem to be two regulatory regimes between Class D licenses, passenger license holders, and commercial driver's license holders. The court is correct. It does not make a difference under the statute, but
Under the statute as of today. At some point, it did make a difference, right?
yes, it did.
And they
Yes, it did,
changed
sir.
that. And they made a strategic change to that to bring in the personal vehicles. Would you agree with that?
That's correct. They did so in this case, in Mr. Perry's case, after he had obtained or suffered his first strike, which was in 1998, in Dorchester, and resulted in a continuance without a finding of his case. Then the CDL statute only applied to crimes such as operating under the influence, where the operator was actually operating a commercial vehicle.
That was at the time that he took his quaff,
Yes, yes.
and at that time, he didn't have a CDL license.
He
Is
did
that
not.
fair to say?
Not. And so then when he applied and received his CDL license, he did so. It came with one, apparently with one strike, something not known to him, and something which didn't.
So nobody, you're saying there was no warning to him at that time, hey, you already have a strike?
I'm sorry, Madam Justice.
You're saying there was no warning to your client when he got his CDL that he already had one strike against him?
That's correct. I mean, he, in the 1998 incident, he applied for, was accepted for the alcohol safety program.
Right, for the quaff.
Took the quaff, and then got on with his life, and shortly thereafter applied for a CDL and obtained it, and has been has driven without incident for 20 years until this 2018 arrest.
So there's no factual dispute that he declined to take the breathalyzer, right?
That he?
There's no, you agree he declined to take the breathalyzer, right?
Oh, no, that's absolutely right.
Okay. And I guess one question I had was, the Hallinan decision is about a particular machine, the Alco-Test 9510, how do we know what machine he was offered to take a breathalyzer? Was that the only machine in the Commonwealth?
That I don't, I do not know that he refused the test. I read the Hallinan case as really a condemnation of the Office of Alcohol Testing, because all of these machines involved in breath testing ran through the Office of Alcohol Testing.
Right, but the Hallinan case is specific to the Alco-Test 9510 breathalyzer.
Yes, but he declined the test offered, and actually I have no information as to the type of machine that was the case over there. I wasn't trial counsel in the district court, and after Mr. Perry declined the test, paid the penalty, the statutory penalty for loss of license, he went to trial and was acquitted.
Right. But you noted in your brief that district attorneys, and I'm trying to speak up, but I have a cold that might be noticeable. District attorneys said they would not use the breathalyzer results except for the case of death or injury. So what do we make of the fact that they were willing to use the results of this, or try to use the results of this machine in cases of death or injury?
Well, the breathalyzer machine, it only provides some indication of a person's sobriety. And as I read Hallinan, it was the results were presumptively presumptively excluded, except that in the case of serious injury, there could be an evaluation as to whether or not that there was other evidence justifying the retention of the conviction.
So his accident happened in December of 2018, correct?
I'm sorry, sir?
I'm sorry, I said accident. His offense for OUI happened in December of 2018.
Yes, sir.
Okay. And in August of 2018, in your brief, you say that the Commonwealth District Attorneys stipulated that they would exclude breath test evidence in cases involving a violation of Chapter 90, as Justice Henry just pointed out, in cases involving death or injury, which his was not. His had nothing to do with death or injury, correct?
Yes.
All right. So he knew in December that any refusal or any breath test couldn't come in against him because the district attorneys had already stipulated it, that they wouldn't use it. You follow that?
Yes, but he was penalized for the refusal.
Why refuse? If you know that they can't use it against you, then why refuse?
Because because once burned, twice shy, to be quite honest about it, sir. And once burned goes back to 1998.
In 1998, had the district attorney stipulated not to use breath tests?
No.
Okay,
but,
so I don't see how it's once burned. I don't see that.
Well, it is my client's view or opinion that the 1998 test unfairly scored him. But
that may be true. I don't know.
Nor do I.
My question's a different question. I'm talking about the second offense, and why would he be motivated not to take the chemical test, knowing full well that it couldn't be used against him? Knowing full well it couldn't be used against him.
Well, because because in his view, the test produced an unreliable result.
And it appears that the district attorneys agreed with that, and that's why they stipulated not to use it.
Well, but the district attorney, this did not occur at the time that he made the decision, which was in the police station, which was in the police station following his arrest. There was no district attorney there.
You tell me that on August 14th, he was aware that the district attorney's office had stipulated that they wouldn't use them. His offense occurred in December of 2018.
Yes.
So it was after the stipulation was in effect that he was aware of, per your brief.
No, then if...
Take a moment. I mean, I don't want to put words in your mouth, but I'm just reading from page 20 of your brief. And you point to Judge Brennan's memorandum.
I see what the court is pointing to. Well, I mean, that's just a fact that is in the brief, that my client was not aware. My client didn't have that information on December 18th as to what the Commonwealth's district attorneys
So you're saying your client knew that the breathalyzer was not reliable, but he didn't know, or there's no indication he knew that the district attorney said they wouldn't use the results?
That's correct, Madam Justice.
And
And he did not know. I mean, I think it was a feeling that these tests were not reliable, and that's what prompted his refusal. His refusal was presciently correct, he feels, under Hallinan.
So I think what you're arguing is that we can take the Hallinan case and extend that to just even exclude the existence of the test altogether, is that right? So it then becomes not a strike.
Yes.
But what's our authority to do that?
Well, because as I read Hallinan, and the test is unreliable, or was unreliable, and should not be counted as a strike. I made an analogy to it being a pass ball or something else that is chargeable against the Commonwealth. It should not be charged. It should not be charged against this man to result in the lifetime forfeiture of his the license which he possessed in for some well, it was about 15 years without incident, in which he uses to earn his living.
So I think you go.
So harsh result. I think I understand. It's a harsh result. Hallinan didn't speak to chemical test refusals, did it?
Yes, but Hallinan involved breathalyzers.
I understand. And it spoke to breathalyzers and said for that 8-year period of time, any breathalyzers can't be used. But it didn't say, and that also applies as to chemical refusals. And they could have, right?
Yes, the court is, you are correct, it didn't, but there was only, we're not suggesting that the government was guilty of a bait and switch. I mean, all of the machines in use at that time were unreliable. I would also indicate that Hallinan quite forcefully makes the point that the period of unreliability what is greater than it should have been had the Commonwealth cooperated and obeyed the findings of the particular courts involved. The Hallinan period was extended for from 2014 to 2019 because of the Commonwealth's obdurate refusal to obey particular orders of the court regarding discovery. And so, given this, we think that the test is unreliable and should not be counted as a strike against Mr. Perry.
Now, one of the arguments you make is a due process argument, that given the severity of the sanction here, more process was due. If the agency is correct in its reading of the plain language of the statute, what purpose would additional process serve? What would that process be looking at?
The process, the process.
If the statute does not emit of exceptions, then you could have all the process in the world, but it's not targeting anything that will help your client.
I understand. Yes, I understand what your points are. But the statute, there's a problem with the statute. The federal regulation relies on the state to implement its terms. And what happened here was simply that where you have the federal statute that has no exceptions in it, that which was the statute that was adopted by the legislature. Nobody is watching the watchman, and you have this problem which Hallinan addresses, and to then turn around and say, well, the statute says what it says, and therefore my client should pay the penalty of a lifetime exclusion from this license that he owns, that he earns his living with, is
Your time has expired, so we need to be brief. I mean, you've painted a picture of that this is a harsh result and that, you know, your client is sympathetic. You've done a very good job in terms of advocating for him, but why are we the right venue as opposed to getting the state to put in the 10-year limit?
Well, that's not going to that's not going to help my client get back to that's my answer to that, Madam Justice.
Thank you. I think we understand your argument.
He's already been 4 years without his license, and
Counsel, I think we're going to have to leave it there.
thank you, sir.
Thank you very much. We'll hear from the agency.
May it please the Court, Jennifer Graney, Assistant Attorney General for the Registry of Motor Vehicles and the Board on Motor Vehicle Liability Policies and Bonds. Your Honors, the commercial driver's license statute covers drivers of very large, very heavy trucks, including trucks that transport hazardous materials and large vehicles transporting many passengers, 16 or more.
So when was the statute changed to include drivers of their personal vehicles?
In 2006, Your Honor, the statute was changed here in Massachusetts. It was before that at the federal level, but Massachusetts adopted it in 2006, which made an infraction in the personal vehicle also a trigger for the revocation.
And when did Mr. Perry obtain his CDL?
I believe Mr. Perry obtained his CDL in 2001, prior to the change in the statute.
And so he wasn't aware, arguably, that a operating under the influence charge while operating his personal vehicle or a refusal for operating to take a breath test while operating his personal vehicle. He wasn't aware of that when he obtained a CDL in 2001.
Right, so in 2001, that would not have been a trigger. In 2006, when the law changed, he was driving as a commercial driver, and there's no evidence one way or the other, but I think it is safe to assume that he wasn't necessarily having actual knowledge. Perhaps he did, perhaps he didn't. But for purposes of this argument, it's safe to assume he did not have actual knowledge. But at the end of the day, the law is that he is in fact presumed to know the law. And the citations...
In fact, it wasn't until 2015 that the SJC said that a 24D quaff was a conviction for these purposes, correct?
That's correct. In the Tirado case, the Supreme Judicial Court said at that time that a quaff is in fact a trigger for these types of cases. So his...
Somewhat counterintuitively, I might add.
Your Honor, I would point to the language of 90F Section 9 in terms of whether that result in Tirado was counterintuitive. It does include words related to annul pros, I believe. So words that are relevant to the idea of a quaff are included in the statute.
So if the Commonwealth offers someone a breath test, but the Commonwealth knows its machine is broken, right? And then the person says, no, I'm not going to take the test. You're saying that would still count as a strike?
Your Honor, I'm suggesting it would have to count as a strike under the plain language of the statute because Chapter 90, Section 9F says that the Registry of Motor Vehicles shall revoke the license after the second trigger, and one of those triggers may be a CTR, a chemical test refusal. So that there may or may not be an evidentiary issue in the related criminal case really doesn't have any impact on what the registry is required to do by the legislative act.
Well, but let's say that for whatever reason, I know I'm using an extreme example, but I'm trying to understand the bounds of your argument. So let's say somebody in that office that calibrates the machines just set them so that no matter what happened, when someone blew into the machine, it was going to show 0.10, which is over the limit, right? And then they offered that and the person refused, you'd still say that's a strike?
Well, under 24(1)G of Chapter 90, there is an opportunity to appeal the automatic chemical test refusal suspension. It is to be done within 15 days after the arrest. There are three
Right,
issues.
but the point I'm trying to make and what I think he's trying to make is that when the Commonwealth says this can be a strike, that the Commonwealth has some sort of underlying obligation to provide a machine that works, and that the Commonwealth wasn't meeting that obligation, and so that's unfair. Why is that wrong?
I would suggest that this is precisely the reason that Hallinan came out the way it did, that the Supreme Judicial Court has recognized that it should not rely for the purpose of criminal convictions on breathalyzer tests that were inadequate and unreliable. But that is in the criminal context. In the civil context of the license revocation, under Section 24(1)F1, all drivers in the Commonwealth consent to take a chemical test of their breath or blood as a condition of...
Right, but in terms of good faith and fair play, the presumption there is that the Commonwealth is going to offer them a test that works.
Your Honor, I certainly would agree with the court that the Commonwealth should use tests that work in terms of the breathalyzer and the blood test. However, the Registry of Motor Vehicles is unable to make a distinction and to second guess on its own whether a chemical test refusal that clearly happened should trigger the suspension due to reliability or unreliability. That is simply not something that can be litigated at the Registry of Motor Vehicles or the board.
So, I mean, it seems to me that there's something arguably fundamentally unfair with the way that this has played out with respect to Mr. Perry. So, Mr. Perry is not a lawyer and may not know the nuances of taking the breath test and refusing the breath test. What he knows is the breath tests are bogus, and he has a suspicion with the government never stopping black drivers, just growing up as a black man in Boston. He's wary of the government, of police conduct. And so he says, I'm aware that these tests could be bogus. I'm not taking it. Anything wrong with that?
Well, Your Honor, he certainly has that right to refuse to take the breath test. And many persons who are stopped or arrested for OUIL do refuse the breath test. But the statute that the Commonwealth must implement, the registry statute, does not allow the registry to consider one way or the other the reasons for refusing the breath test. It is a clear...
When you said there's a right to appeal a refusal-based suspension, what are the grounds on which someone can challenge that?
Yes, Your Honor. So it's very limited. There are 3 potential grounds. One is, did the police officer have reasonable suspicion to make the arrest? So there is an opportunity to appeal the actual reason for the arrest or the stop. There has to be some reasonable reason to give the breath test in the first place. Then, secondly, the question is whether he, excuse me, Your Honors, I'm so sorry. One of the prongs is whether the person actually did refuse the breath test. Whether the person refused the breath test is a factual question. Sometimes people suggest that they didn't actually refuse it. And the third prong, which I know I have here and is escaping me at the moment. I apologize, Your Honors. I apologize, Your Honors. Oh, thank you. That he was in fact arrested. Thank you, counsel.
I
I
couldn't hear you.
apologize for that.
What was the third prong?
That he was in fact arrested. There was an arrest.
Arrested.
There was a reasonable suspicion, there was an arrest, and there was a refusal. Those are the 3 facts that the RMV and then the board can consider.
So,
Could Hallinan have included refusal of the breath test, chemical refusal?
I'm sorry, Your Honor, I didn't hear
Could
you.
the Hallinan court, could they have included not only we're going to exclude the breath test results during this fixed period, but we're also going to exclude anybody who refused to take a breath test?
I don't think it would have been correct for the court to consider the civil consequences of refusing to take the breath test in the Hallinan case. The Hallinan case itself is purely a criminal case. It was purely about the evidentiary impact of the tests that were deemed to be unreliable. And it was not before the court to consider any civil consequences of refusal of the breath test at that time.
so if I understand you correctly, Mr. Perry, if he had taken the breath test and he had blown like a .20, I mean a really high score, but he'd been acquitted, you couldn't use that.
That is
He'd
correct,
keep
Your
his
Honor.
license.
If he had taken the breath test, he would not have had a CTR. If he had then proceeded to trial on the criminal case and was acquitted, he would not have had a trigger based on that event for purposes of the commercial driver's license.
And if the police officer had said, you have a right to take a chemical test or a breath test, and I just got to warn you, dude, this machine's a little wonky, and sometimes it's right and accurate, and sometimes half the time it's not, and he refused to take the test, you would still use that refusal as a strike.
Correct, Your Honor. There's nothing in the statute that allows the registry or the board to consider the reason why the person refuses to take
Okay, and
the
so
chemical
his response to that is wildly unfair, that cannot possibly be consistent with due process to offer a defective test and then say, oh, you didn't take it, and so you have a strike. What's your, I mean, because that does, to the person on the street, that sounds kind of unfair.
Yes, I understand why it sounds unfair. In terms of due process, though, there's no allegation here of any irregularity in terms of procedural due process. Mr. Perry received 2 hearings at the board. He then was able to appeal under 38. In terms of
No, you have him in that he doesn't contest that he refused the breath test, and then he had all the procedure of the criminal proceeding where he took the quaff. The issue is really not that. The issue is the Commonwealth meeting its obligation when it imposes this as a potential strike, if it then doesn't offer a fair test. That's your problem.
So the analysis in terms of due process about the statute itself and whether it is in fact constitutional under substantive due process is whether or not it involves a health and safety measure, whether or not it's within the police powers and bears a rational relation to the health or safety reason for the legislation. It is a very low bar to overcome substantive
Right, but
due process.
one could argue that the agency is really acting like a clipboard-bearing troglodyte. It's just saying, I got a checklist, and what we did was totally unfair, but we're going to ignore that because we got a checklist.
That is essentially correct, where the legislature has required the agency to act in a particular way and has not granted discretion. Agencies are all...
Why wouldn't we be the relief valve then? Why wouldn't we say this is fundamentally unfair and you can't count this because you didn't uphold your end of the bargain, which is providing a fair test?
So it would not be appropriate for the court to second-guess the legislature's decision to enact Chapter 90A.
No, we wouldn't be. We would be saying that the agency didn't do its part.
I think in order to say that,
The agency being the people offering the breath test.
in order to say that, the court would have to find support for the idea that the registry can read into the statute some sort of discretion, and in fact, that it could use that discretion to examine the reasons why.
That's why I'm going to take you back to one of the earlier questions I asked you. If the officer said, you can take a breath test, but the officer knew there was actually no machine, right? But he said, you can take a breath test, and the guy says, I'm not going to take the breath test. Under your standard, you're like, that's totally fine for us. And then the guy who says, oh, I'll take it, and there's no machine, you're like, he gets off, but the guy who's like, no, I'm not going to take it, he gets whacked.
Well, I would not say that's totally fine. I would say that that situation is not this current case, but I also would say that as a matter of practical implementation of the statute, it cannot be the case that the registry is responsible for the decisions that happen at the police station. So if, in fact, there were some sort of fraudulent situation where the officer knew perfectly well that the test wasn't functioning, there's no mechanism for the registry or the board to reach that issue.
But why isn't that exactly the situation we have here? The officers all knew that this machine was not, I don't know the details, but properly calibrated, or I'll just say wonky, right? And they offer the guy the wonky machine and he refuses. I mean, so this poor guy draws the wrong conclusion from the newspaper article. Whereas Judge Desmond, who's a very smart guy, is like, well, he should have just said, I'll take it, because who cares? You can't use it. And you have this crazy, you're like, well, he can blow a .2 and it's totally fine. He keeps his license.
Excuse me, Your Honors, I know my time is up. If I could just address that.
And we have at least one more question.
Okay. So the statute is quite clear that there is no exemption, that if you are driving on Massachusetts roads as a condition of the privilege to drive, you have consented to take the breath test. And there is no exception to that at all. The fact that that has collateral consequences that are, as the court acknowledged and as the agencies acknowledge in their brief, that are quite harsh in the particular area of commercial drivers, that is not something that can impact whether or not the test is itself mandatory. It clearly is mandatory by statute.
So I was asking counsel whether or not Mr. Perry should be held to the fact that the district attorneys had stipulated that the breath tests themselves would not be used for a fixed period of time against offenders who took the breath test and blew a certain number, of which he was one. And he informed me that that's a fact, but not a fact that was known to Mr. Perry, that the district attorney's office had stipulated to it. Is there any record support that Mr. Perry was aware of the facts surrounding the breathalyzers and the fact that they were deemed unreliable?
I don't believe there's any record support for that at all, Your Honor. There isn't anything in the transcripts of the hearings or any documents that would suggest that Mr. Perry was specifically aware of that information. I would just say, however, that what may or may not have been within Mr. Perry's thinking in terms of motivation for declining the test really isn't something that the registry can consider. The legislation does not permit the registry to consider that information.
And the legislation is intended to protect those lawful drivers on the roads of the Commonwealth from potentially drunk CDL drivers who have these huge vehicles that could wreak havoc on the roads if somebody was not sober.
That is correct. It is a health and safety measure. It's clear from the preamble of the legislation that it was adopted to be a remedial safety measure. And in terms of this question of what is health and safety versus what is punitive, the Murphy case speaks to that, and so does the Bruno case, which involves actually civil commitments for sexually dangerous persons. So there are other contexts in which health and safety statutes are upheld.
Challenging case, I think we get it.
Thank you both very much. Very interesting matter, which is now submitted.
Thank you very much, Your Honors.
Our fifth case of the morning is MB versus AG 2023 P286. I would remind the parties that the names of the parties are impounded. I would, for one, find it most useful just to refer to them as plaintiff and defendant. There's something about initials that are hard for me to follow.
Change that around. Okay, I thought that was the sixth case.
Good morning, Your Honors. May it please the Court. My name is Paul Lewis, and I represent the defendant appellant AG. Today we are asking this Court to vacate the abuse prevention order extension that issued on February 10th, 2023. As a threshold matter, Your Honors, and this was the first issue in my brief to which Plaintiff's Counsel did not directly respond, on page 19 of the first volume of the appendix, the abuse prevention order initial complaint is included there. In that abuse prevention order complaint, the plaintiff proceeds only on one technical alleged ground, and that is that on or about certain dates, the defendant placed her in fear of imminent physical harm. In doing so, and this is important because it's a pre-populated form, she expressly and affirmatively declined to also check that the defendant attempted to cause her physical harm, the defendant caused her physical harm.
But she did allege that in the course of the proceedings.
As a technical matter, that is not there were no other statutory grounds, Your Honors. And that's important. It's important as the Dolan case recognized, because on looking at 1B, these extensions cannot, quote, merely respond to past alleged abuse.
So you're saying if the plaintiff checks off the wrong box and only, say, suggests, possible imminent physical harm, but then she testifies he raped me every day, that when the judge issues the restraining order, it doesn't fall under that subsection, even though she gave that testimony?
Your Honor, so there were, I have a couple of responses to that. There were several possibilities, and she proceeded only under Section 1B. It's also significant.
I understand she checked a certain box, but
Yes.
what I'm saying is, not her in particular, but just generally, if a person checks that box, they don't check rape, but then at the hearing they say he raped me every day, you're saying the judge ignores that and just sticks with the box that she chose.
I'm not saying that the testimony should be ignored. What I am saying is that, as this court has reiterated in multiple cases, Smith v. Jones, Cortez, and Carroll, and I'm quoting Carroll here, when the 209A order was apparently sought and obtained on the basis of 1B alone, that limits the court's review. Additionally here, that point is even stronger in the context of this particular hearing, because at the outset, Judge Kunis stated to the parties that he was expressly limiting his review to determining whether at the time she was testifying, this was February 8th of 2023, she can articulate a serious imminent, a fear of serious imminent harm. And there was no objection, there was no request that the standards should be different. It is possible, Your Honor, to obtain an initial one or an extension or a permanent one on the basis that at some time in the past there was a serious rape. The Vitoni case, which I know my brother cites, is important for that point. In that case, there were rape of minors. There were the minors were testifying against the defendant, even though he was not allowed to speak to them during his 8-year incarceration. He was nevertheless intimidating them using the internet and blogs and other third-party mechanisms in those types of situations. And this is what happened in Vitoni, where there is a allegation, and that's the basis of this rape that occurred, then it is conceivable to base it on past abuse alone. By contrast, this line of cases, Dolan, and then this court's applying Dolan, for example, the BT case, the Mussman case, the Smith v. Jones case, and the Cortez case, stand for the proposition that even if there were serious allegations of sexual abuse or alternatively violence several years in the past, 3, 4, 5 years in the past, and I'm speaking to BT and Cortez in particular, and to a lesser degree Smith v. Jones in particular here, even if those things happened, and we dispute that there were such allegations here, and even when there's unwanted contact 3, 4 years after the most recent incident, that unwanted contact in and of itself under 1B does not give rise to a serious fear of a reasonable fear of serious imminent harm. And
Is it simply a one-bit choice that you're on this path or you're on that path? Do you know the Callahan case?
yes, Your Honor, the one that discussed Dolan. Is that correct?
And Callahan talks about how where there is past physical harm, then it's a different standard. But it also makes clear you don't automatically get an extension just because there was past physical harm. It's a universe of factors, kind of a test. So if there were credible allegations of rape and physical harm, regardless of which box is checked, isn't that a factor that we could take into account in determining whether or not even there was a reasonable fear going forward?
Your Honor, my response is twofold. Callahan did say that Dolan should not be rigidly limited, right? And Callahan, I think, stood for the proposition that the totality of circumstances, one could factor that in. But that doesn't change this court's precedent that you can't merely respond to past abuse. And again, the applications are in Dolan, BT, and Cortez. So there were serious allegations 3, 4, 5 years ago prior to the abuse prevention order extension hearing. And then recently, there was some sort of contact, particularly in BT and Dolan, but that contact itself was not inherently threatening. That contact itself did not in and of itself threaten violence, and that is why this court in those cases said an extension was not appropriate.
So the affidavit that's in play is Record Appendix 21, is that correct? Is that what you said? That's what she...
Are you referring to the ex parte affidavit, Your Honor?
Yeah, is that Record Appendix 21? I want to make sure we're talking about the same document.
Yes.
Okay. And so she leads off with, I'm scared of my husband. That's the first thing she says, right?
Right.
And then she says that he just got released from a hospital, right, where he threatened to kill himself. This is all part of the ex parte. So you're saying that this is what's inclusive that we can look at to determine whether she was reasonably in fear of imminent physical harm. Is that
I'm saying that I have two responses to that. Under the circumstances, I think to your colleagues, Justice Milkey's point, there is case law post-Dolan that says you can look at the totality.
I'm asking you specifically,
But
this
no-
ex parte affidavit, which I think you led your argument with, is the world, the totality of what she alleged in support of her request for the order. Is that your position? And in it, you say there's nothing in there that should rises to the level of reasonable imminent physical harm.
No, Your Honor, that's not what I'm saying.
All right.
I have a couple of responses to that. For one thing, in that ex parte affidavit, the harm alleged was much more recent, and I'm not appealing the ex parte order or the order that issued about a week later. I'm not. Separate and apart.
And we don't have transcripts of anything that happened in those hearings, correct?
No, Your Honor. Separate and apart
But in
from
the
that.
affidavit, she specifically says that he has continued to have sex with me when I'm saying that it hurts and ask him to stop, right? I mean, we have a case that says that's rape.
She says, I'm scared of leaving him. We're going through a divorce right now. She says, I'm scared because he was just recently hospitalized, because he's threatening to kill himself. So I'm asking you, I want you to finish your answer, which was...
Thank you, Your Honor. Well, it's also my answer,
All right.
separate and apart from that, that the ex parte evidence itself cannot be substantively considered after the initial. So there's the ex parte hearing approximately 10 days later, and this is what happened here. There's an initial two-party hearing. It's my position that the initial two-party hearing is the only time where that ex parte affidavit could substantively be considered. And the case law support for that is the RS versus ABP case, 95 Mass Appeals Court 372 at note 1 from 2019. It's the only, quote, review provided by law.
I understand. So point to the affidavit that she executed at the hearing that issued this order. Tell me which
She did not execute an affidavit at the hearing for this order. She also did not execute an affidavit in 2022.
But we do have the written statement she did sign from 2022 in this record.
Yes, Your Honor, but I would wholeheartedly object to the notion of considering it. And this was actually the issue that we argued before your colleagues several months ago in connection with 2022 P1046. The 60B affidavit was my 60B affidavit, and I said it is not in the court's record. It's not in the docket. You can review the docket. It's not there. She never submitted it, and this is on One affidavit of mine was 61, stating that it wasn't there, and then the other affidavit of mine, which is a motion to reconsider, says it's not there, 67 to 68, and accordingly, your colleague Justice Rubin opined that there was no way to find that it was submitted. It wasn't submitted, and even if it had been submitted, it wasn't under oath.
When you say opined, you're talking about a comment from the bench?
I wanted to be careful with my words.
My understanding, there's no ruling in that case.
That's correct. That's correct.
Okay, so in terms of your First Amendment argument, she's saying that at the hearing, nobody ever raised a First Amendment objection, that it is in the written exhibits, but that it was not actually raised before the judges. Where was it raised before the judge, besides the exhibits?
So what, as you said, Your Honor, there's an exhibit on 98 that articulates, it's also an exhibit on 104 to 105.
But it's not outside the exhibits, correct?
I'm sorry, Your Honor?
It wasn't made in the hearing other than the exhibits, correct?
I would disagree, Your Honor, on
That's fine, I just want to know where it is.
177 to 178, which is from the hearing. I am making an objection on the joint, because the issues are sort of intertwined, the joint basis of the res judicata, i.e. estoppel being
Which language on page 178 are you citing? Or is it 179? Because I'm not seeing the objection. You're on RA, you're in the Record Appendix 1, correct?
So I say, that was 177 to
Line what?
178. It's the spot where I do object on the basis of res judicata, and the court, I'm sorry, Your Honor, I might be incorrect. The court expressly states that Judge Kunis was the judge there. He took notice of that. He overruled my objection. That's where I preserved the objection. It's true, to Your Honor's question and to my brother's counsel's brief, that I didn't literally say the word First Amendment, but I didn't have to here. There are two reasons I didn't have to. For one thing, because as Judge Kunis said, he remembered the case, he remembered the argument. He was the judge there. It was submitted prior to the hearing as a motion for judicial notice, as well as the argument coming in directly.
All right, so I understand that you're saying it's here on page 177, so we'll look at that. I'm correct that when the families were communicating through the Family Wizard application, that the communications were to be limited to the child, right? That was the court order?
That's correct, Your Honor. However, that's where the exhibit comes in that contained the argument itself.
What's the that?
Sorry?
You said that's where. What that?
Oh, that's where we're discussing the judge being in front of Judge Cafazzo, and they're discussing the transcript. The argument was contained within that transcript, and this is on 177, and that came in as an exhibit. Additionally, in my reply brief, I respond to...
You're referring to Exhibit 17? Or, well, the clerk then says Exhibit 18. I don't know if those are different or the same.
It's Exhibit 18, Your Honor. That's the probate and family court transcript where I expressly make that argument, and I'm discussing it there. I would also state that under Idris, the notion of having to do an exactly narrowly tailored argument in that respect does not apply. But here's the page, Your Honor, on RA Volume 1, page 100, and also separately, RA Volume 1, page 151, I argue, quote, charges never should have issued for this conduct, the implication being because it was protected, but we don't discuss it more because Judge Kuhn says, I remember the argument, I understand.
Is this really a First Amendment argument as such, or is it that the parties were allowed to communicate about the child, and this was sort of within the penumbra of that?
I think it could be characterized in either way, Your Honor. Under the NG case, This court held that statements may only constitute the basis for civil restraining orders. Granted, that was a harassment prevention order, but the case law is the same, if they fall outside of the protections of the First Amendment, such as when it constitutes fighting words or true threats. And it's my position here, as I successfully argued in the context of the criminal case leading to a binding with prejudice dismissal, that these were neither true threats nor fighting words, and in fact, they were inherently, presumptively permissible due to the probate court's order.
Whoa. I mean, how is "I like your glasses" about the child?
Your Honor, I like your glasses is not about the child. However, it is not a fighting word or a true threat.
No, but it's a violation of a court order, isn't it?
The First Amendment precludes criminal liability, and that's what the district court found. It's not I would submit that it is not a violation of the court order, and this is Commonwealth versus...
Well, it may not be a violation of the court order, but I don't see, I mean...
This is the Commonwealth versus Silva 431 Mass 194 case. Provided that the defendant speaks to the protected APO plaintiff parent in a direct and non-abusive way, it is not a violation. It can't be a violation because, quote, contact would be lawful incident of the court order that permits it. And the Commonwealth versus Silva case actually discusses exactly the point at which, under those facts, the statements themselves became a violation. And undoubtedly, under that opinion, had the opening line been, oh, by the way, you know, nice glasses or something,
Right,
it would not
but
have
he
been a
also
violation.
said, he noted that a particular date was the anniversary for the parents, and that's definitely not about the child. And it also indicates he's ruminating about the relationship. And it seems to me that a willingness to violate an express court order saying limit your discussions to the child is a red flag.
Your Honor, inherently it does not threaten imminent physical harm. Whether it was appropriate or not, whether it should have been done is not the issue before this court.
Inherently goes to the parties. Maybe it wouldn't for you, or maybe it wouldn't for me, but with respect to the relationship that she had, that may be a very subtle or inherent threat to her. And that would be arguably reasonable based on the context of their relationship. So I understand you seem to focus on, you know, whether or not she said, I'm reasonably in fear of imminent bodily harm. And she didn't use those words, and so therefore she's out. That's what I kind of gather from your argument at its core.
That's only a substantive facet of it, Your Honor.
Well, that seems to be...
Sorry, subjective facet of it. The objective facet of it is that objectively, I mean,
Objectively, we have a defendant who I wouldn't have known until I read the other brief, who had alcohol issues and seemed to have problem with his conduct and behavior when he was drinking, who had mental health issues, who seemed to have risen to a level that he had to be hospitalized at least on one occasion, all information that's known to her, who had made these kind of innocuous comments about her appearance or about, I hope you get home safely, that may have led her to be concerned for her safety based on his ability to either look at her calendar through the Google Calendar, monitoring her comings and goings, which really have nothing to do with Forrest in the welfare of the child. Do you agree with that?
Your Honor, the comments in January, as Judge Kunis actually observed during the hearing, were directly related to Forrest. They were directly related to his being upset that she had unilaterally, suddenly, for non-emergency reason, canceled his scheduled visits to fly to Oklahoma to have Forrest be with her abusers.
Now, how did he know that? And what does her abusers have to do with her fear of him?
He was saying those things about Forrest's safety. I would submit that that was the motivation in saying those things, and that's exactly what Judge Kunis expressly observed on RA 1-377. He said, it seems like a lot of what AG was doing and saying, a lot of what the defendant is saying, a lot of it, what he's doing is about getting access to his child as opposed to threatening violence. The standard that...
Much of it may have been. A lot of it may have been. Not all of it. So much of it may have been. But that's not the issue. So you also seem to argue that, you know, she kind of baited him into having these communications, that she kind of lulled him into believing that it was okay to have these communications. At the end of the day, it's his responsibility to know what he can do and what he can't do, correct?
Your Honor, I mean, technically that's true, but that doesn't mean that what he had done in making these pleasantries, have a great day, MK, like the new glasses, best, comma, AG, that does not mean that that was a threat and intended.
If you read them that way. but there's an alternative way to read them where it could be a subtle threat.
I would draw the court's attention to the pages on volume 2 between 237 and 258. These are the Our Family Wizard communications between the parties from the time at issue, April of 2022 and May of 2022. Those speak for themselves. Those completely and undoubtedly evince the parties' cordial back and forth that had been going on. And to the extent that this court is suggesting that, these could have been intended some other way or read some other way, I would just provide the court with the information that, again, between 237 and 258, she is texting him, it was wonderful to see Forrest do this, it was...
I'll just say child.
Does that include the statement where she alleges that he had made some comments to her? He then speaks with his lawyer, and the lawyer tells him, I told you, have no conversations with her other than about Forrest. And he says, I know you did, I effed up.
It does, because that police report is the spring 2022 police report that encapsulates all of those Our Family Wizard.
In 237 to 258.
Yes, and that's the time period as well. Some of the Our Family Wizard communications might have come in once or twice, but that's the time period that encapsulates, to Your Honor's question, those statements were made between April and May of 2022, and the 237 to 258 statements between April and May of 2022 as well. And the plaintiff at one point...
Counsel, we're 7 minutes over.
I understand.
We're going to have to leave it there.
Thank you.
Thank you. We'll hear from the plaintiff.
Good afternoon, and may it please the court. Nick Madison for the appellee MB. The issue before the court in this case is whether the lower court judge abused his discretion in extending the APO in this case. And because there's a substantial basis in the evidence from the hearing to find the standard be met, there was no abuse of discretion in this case.
Do you agree with him that we're limited to the box that she checked?
No, Your Honor, I don't agree with that, particularly where, as has been noted, there was, that was the ex parte, the process to begin the ex parte hearing in December of 2020. There was those allegations were before the defendant. He was on notice of that for the first extension in January 2021. They were before him again in the second extension in January 2022. And again, when there was a further extension hearing in February of 2023, he was amply on notice as to what the plaintiff was alleging occurred during the marriage here. And so to argue that he wasn't on notice is, just is not consistent with the record. So the court can consider the serious sexual abuse alleged.
Now, part of the defendant's argument is there was no actual evidence, and we're somewhat hamstrung since we don't have the transcripts from the early hearings. But putting that aside, I understand that in the other pending appeal, your argument is that the parties essentially agreed to be heard on representation, so there was a degree of informality involved.
That is correct, Your Honor. At that extension hearing, which was the 2022 extension hearing, which was still during COVID, it was done by video conference software. The judge invited the parties to make proffers or representations. There was no, which the parties then did, both parties, the plaintiff and the defendant, by and through counsel, and there was no objection to that, and the judge decided on that basis.
And did the allegations of rape or other violence come out during those representations?
Your Honor, and this is where we get into the weeds a little bit, there was a signed statement that was referenced during
The one at 64.
Correct, Your Honor. The prior appeal is about whether or not that was in fact before the court, but what's without a doubt is that it was before the court in this 2023 extension hearing, because at one point there was some debate over whether and how the document got into the court's file, And the judge at one point said, "You mean this document?" and held it up and referenced that he was going to read all of the affidavits within the court file when plaintiff's trial counsel said, "Your Honor, would you like me to go through all of these prior affidavits?" And the judge said, "No, I will read them. Let's move this along." And so all of the initial ex parte affidavit and the signed statement were contained within the file. They're contained within the record appendix here and may be considered by the court in determining whether or not the standard was set. But I'd also like to point out that whether or not this is considered as only on the basis of prior sexual assault or on the basis of a reasonable fear of imminent serious bodily harm or imminent serious physical harm, the court may consider the prior abuse. The prior abuse may inform her current fear, particularly where the abuse was serious sexual and physical abuse that's alleged.
So he argues that, any extension of the order was a violation of his client's First Amendment rights because these statements were all innocuous. Assuming he didn't waive the First Amendment, why is he wrong?
For several reasons, Your Honor. One is that these statements could be considered true threats. If the judge found the statements caused the plaintiff to have a reasonable fear of imminent physical harm, imminent serious physical harm, that would meet the standard for a true threat. Secondly, Your Honor, the argument put forward by the defendant here that, notwithstanding any court order, I can say whatever I want to somebody protected by an abuse prevention order, and that's protected by my First Amendment rights. That does not have any basis. It would render no contact orders and abuse prevention orders essentially nugatory. They wouldn't have any force anymore. And so in my brief, I cite to a range of cases that say you don't have a First Amendment right to essentially talk to an unwilling speaker. The plaintiff she wasn't a public figure of any kind. He wasn't posting this, he wasn't shouting it from the city square. He was directing it directly to my client, who was protected by an abuse prevention order. And although the order did allow them to communicate in a very narrow means and on a very narrow content, the statements contained in the Our Family Wizard messages, as well as the statements that occurred in the police station that were subject to testimony in a police report that's in evidence, were outside of that.
How do you address the defendant's argument that if you read some of these exchanges in context, she seems to be perfectly okay with some of the informal banter?
So, Your Honor, I would say the parties were at times communicating civilly within the terms of the order. Much of what the defendant points to as baiting or lulling the defendant were comments about the child. I'm doing this for Easter, so you can do this with him. He's saying these words because we're utilizing an early intervention program. So he's saying these words and oh yeah, these words too. He's talking about what they did and how he ate and occasionally sharing pictures and saying here's something that we did together. All of that was on the content of the child. What the defendant did in this case was talk directly to the plaintiff about outside the scope of the permitted conversation. Which,
putting that aside for
yes.
the moment, I, speaking personally, am having a hard time seeing how a comment like, "I like your glasses," is a triggering event.
Certainly, Your Honor. And I think this needs to be understood within the context of somebody who suffered serious sexual abuse. The plaintiff testified at the hearing that one of the reasons that was so triggering for her is because this is somebody who sexually abused her for years, and he was commenting about her physical appearance. And that triggered the experience of sexual abuse. But I would also respond to Your Honor that we're not just talking about the statements of "I like your glasses." We're also talking about the statement of that he made directly to the plaintiff in the police station, where he's crying and saying, "I just want to make you happy," and blocking her exit during an exchange with a child. He's also saying, in effect, "happy anniversary," which is a bizarre and destabilizing thing to say to a woman in the context of a high conflict divorce where one of the parties suffered serious physical and sexual abuse. And then we also have the evidence of the defendant using his access, which the plaintiff is unaware of how he got access to her Google Calendar, and then commenting through our family wizard, "I hope you both make it back safely," where he otherwise wouldn't have known that she was traveling to protect her safety. And
But he says that the record's clear that she then figured out she had given him access and she had.
the record is not clear. I would differ with the defendant on that. She said during the marriage we shared Google Calendars. She testifies to the lengths she went to try after she left him and was proceeding with the divorce. She said she worked with a domestic violence agency to unshare any context she had, that she worked with her probate attorney to specifically try and unshare any Google account, any access he may have had to her Google accounts. And she says, "I don't know how he could have gotten access."
Did the evidence that she went to see whether or not she had any tracking devices on her vehicle, was that before the court?
Yes, she testified to that during the hearing, and that very loudly speaks to her fear. She got this message, she testified that she was panicked, she testified that she was frantic. She goes to the dealership, she has them look at the GPS that's contained on the car to see if anybody has access to that account. They essentially tear apart the car to see if there's a tracking device on it. They take it to a...
So for some of those statements, I get it. But for others, like, "I like your glasses," how is it that the defendant can reasonably be concerned that that would make her fearful? "I like your glasses."
Well, Your Honor, in the context that he has an abuse prevention order against him that incorporates the probate court order that you can only talk about the children, the child. So he's on notice that the only thing that he's permitted to say is about the child. When he ventures outside of that, the plaintiff is left feeling like she's not protected. And certainly that goes to the basis for her fear is when he's crossing the boundaries of the order, that speaks to her reasonable fear.
And so when he does that at his peril.
Correct.
One way to assure that you don't do that is to strictly talk about the kid.
Exactly, Your Honor. And there's a pattern that emerged in this case of him towing the line of the edges of protective orders, which certainly evinces, the lower court judge could have found evinces an ongoing hostility and controlling behavior that could certainly be considered by the lower court judge in determining whether or not the standard had been met. And I would just like to turn briefly to the issue of res judicata, because I think the defendant has elided an important distinction here. The defendant says that to apply res judicata, there does not need to be mutuality between the parties. That's only partially true. When a party is asserts res judicata against a party who was a party to the earlier decision, mutuality is not required because the party who's going to be bound by that earlier decision had a full and fair opportunity to litigate that. The reverse is not true, and that's what the defendant is asserting here, which is that a non-party to the earlier litigation should be bound by that litigation. The earlier litigation in this case was a criminal case between the Commonwealth and the defendant. The plaintiff had no right or ability to participate as a litigant in that case, and so In Norrington, it states that it would be a violation of due process to bind a party that wasn't a party to the earlier litigation on the basis of that earlier litigation. So I just wanted to address that elision because I think the defendant overlooks that. And unless there's any further questions from the court, I would rest on my brief.
Hearing none, thank you both very much.
Thank you.
The case is submitted. We are going to take a break only so long as is needed to do the hybrid argument. So we will be right back. We will assure Mr. Curhan that we are not breaking long, and we'll let our technical people do their wizardry.
Would all rise, please? Court is now in recess.
Good afternoon, Attorney Saulnier. Am I pronouncing your name correctly?
Yes, Theodore Saunier, yes.
Okay, can you hear us and can you see me when I speak?
Yes, I can.
Okay, my assistant's going to go up to the bench and speak from the microphones on the bench. Can you just confirm that you can see and hear when they speak?
Can you hear me
Yes,
now?
I will. Yes, I can.
Can you see me?
Yes, I can.
Okay, could you go to each station? Thank you.
Can you hear me now?
Yes, I can.
And how about over here?
Yes, and I can see you also.
Okay, terrific. I think we're all set then. Are you the appellant today?
You speaking to me?
You're the appellant, correct? You're speaking first?
That's correct.
Okay, so I think the thing to do would be to just have you quickly mute your microphone, and when the panel comes out and restarts the session, then go ahead and unmute and present your argument at that point. And if there's any problems, we'll try to address them on the fly.
Very good.
Okay, thank you.
Thank you.
Court, all rise, please. Court is now in session. Please be seated.
Hey, Ronnie, can you just turn that a little bit? Oh, no, I guess you can't, because he needs to see too, right?
We are here on our last case of the morning, and that is MARMIK, MARMIK LLC versus Ralph Packer Jr. and others, 2023 P 736. Mr. Saulnier, you have 15 minutes, and I've done a lot of Zoom hearings, but this is my first hybrid hearing. So if we encounter any technical difficulties, we will deal with it as they arise. But the floor is yours, sir.
Thank you, Your Honor. Good afternoon. This appeal comes after judgment in favor of the appellees in a case involving purchase and sale of a property at 27 Lake Ave in Oak Bluffs, Massachusetts. The property sale came along with a couple of different additional agreements between the parties, one of them being an agreement by the Packer people to address the contamination of the property.
If I can just interrupt you, sir, we have read the briefs, so we're familiar with both the facts and the arguments. So if you can cut to the chase to the extent possible, that would be good for both of us.
I'm going to help you along. Did your client move for a directed verdict at the close of the plaintiff's evidence?
We did not.
Or the close of all the evidence?
No, we did not.
So he's arguing that when, in that situation, you can't argue a sufficiency argument. What do you say to that?
Well, I say that the Hatton v. Meade case is right in line with where we are here, in that it can be argued to prevent a manifest injustice. Here, the result was it is an injustice. If I could explain further.
Please.
Yeah, why would you say it's a manifest injustice based on the amount of damages that was selected by Judge Sanders, which seemed to be the bottom rung of the three figures that didn't require anybody else to kind of be in agreement with any outside activity? That is, Nancy's didn't have to sign on, or the ice cream shop didn't have to sign on. It was strictly as between the parties.
The plain reading of the guarantee says that that Packer would make sure that the DEP was satisfied. There was a fourth option also, and that was the one that was selected by the appellee's licensed expert. He actually submitted that to the DEP and went forward and executed that. That's what's presently going on at the property. The DEP is presently satisfied with what's going on.
The Kegel expert? Which expert?
No, that would be his name is Peerduck, and he testified on behalf of MARMIK. And numerous people that testified, the experts, the owner of the property now, they all testified that presently the DEP is satisfied. I suggest that this revolves around the appellee trying to change the meaning of the guarantee to mean not to satisfy the DEP, but to satisfy the appellees. That's the crux of this, and that would be a grave injustice given the plain meaning of the guarantee.
Did Judge Sanders find the plain meaning of the guarantee ambiguous?
She did not, but there was plenty that she did find throughout the trial and the after the post-judgment motion. She made several comments throughout the trial. I mean, dozens of comments stating that she didn't understand the she didn't understand the evidence that was being submitted. It was being submitted in a fashion that was messy, and she didn't get a bound volume of the exhibits, which I believe until day 2.
But counsel, when her written memorandum does not seem to exhibit any confusion and she explains what was submitted to her, why do we worry about a comment during trial where she's trying to get the parties to be clear?
Well, if I could get to the final comment she made was the final after the final witness testified. She made a comment. She didn't understand much of the evidence. That's in the record. And then finally, after the post judgment motion filed by the appellee, she remarked, "Frankly, I think your clients are lucky to have gotten the judgment for $500,000. It seems to me that she was questioning her own judgment at that point.
If I could just return for a second to, I just want to make sure I understand what you were saying about 3 minutes ago. Are you saying that MARMIK is pursuing the natural attenuation option as we speak, having largely won the case at trial?
That natural attenuation has been going on now for years, and it's a result that their expert came up with and submitted to the DEP. The DEP accepted it, and that's what's been going on for years now.
No, but is it your position that that is in effect the option they are currently pursuing?
No, they're pursuing an option which allow them to put residential property on the property. They couldn't do that until after 2017 when the Oak Bluffs changed the zoning bylaw.
Understood, but the value, I mean, the judge priced this, if you will, based on the AUL being put on this property, as I recall.
That's correct, but there is a fourth option, which is also with AUL, and it's for a far lesser amount.
But that
And that's what
would
they're
achieve
operating under
only a
right now.
temporary solution.
A temporary solution which will lead to a permanent solution according to the paperwork that was submitted at trial.
So I'm looking at Judge Sanders' rulings of law, and in her first paragraph, after reciting the guarantee, she says, "This court concludes that this language is ambiguous." Doesn't she say that?
Yes. But I think that it's clear that the part where it's outlining the scope of work. The scope of work is to satisfy the DEP, not to satisfy the MARMIK people or anyone else.
But why isn't it fairly read to say to satisfy DEP with respect to a permanent solution? Because, I mean, the agreement speaks in terms of a cleanup.
Well, I think that's the language that's used in the industry, and a cleanup would also include an attenuation plan, which is presently in effect, and according to the documents that were submitted at trial by their counsel, this will result in a permanent solution.
After how long?
I'm not sure about that.
Was there any evidence at trial to monetize, if you will, and to do a present value of the added monitoring costs that would be involved in the temporary solution?
There was no testimony. However, the only document that I could point to is the one that outlines that option 4, which is $24,000, I believe. And that comes from their expert.
We don't have rebuttal here, so I want to understand, the plaintiff is saying that they're entitled to this extra $105,000 plus interest. Did you file a brief in response to that argument?
No, I did not.
Okay.
What do you have to say about it?
Well, I agree with Judge Sanders that it's speculative in nature, and well, the whole thing is speculative in nature because it's just an estimate. To say that the $103,000 would be what they've expended, I could certainly see that being the appropriate number to then deduct the $35,000, which is in the guarantee, which says that Packer will pay the first $35,000, and come to a number now with that is closer to reasonable. The property was sold knowing it was a gas station, not knowing that there was any residential purpose being used for it.
So one of the solutions required the agreement of a neighbor to an AUL, and the neighbor would not give that. How would that satisfy the department?
I believe that the neighbor that would not give it is on an adjacent property that isn't connected with this. The property that I believe is the one that you're speaking of is 29 Lake Ave, which is next door, and that would be the one that would be needed to agree. And I don't believe they have any paperwork, whether one way or the other. I don't believe I saw any of that. But regardless of all that, they could take and submit to the DEP a plan that excluded that property from this whole situation and just get an AUL on the 27 Lake Ave, the MARMIK property presently.
So one thing I'm confused about is I see everybody quoting the language of the guarantee, but I'm not clear I actually see the guarantee in the appendix. Do you know where it's supposed to be?
Yes, I do. It is very early on.
In the first appendix?
The first appendix, number 4.
Okay, thank you. All right. That's very helpful. And then, are you identifying any particular finding of fact in the order that you think is clearly erroneous?
Well, the fact that the solution selected is erroneous, since virtually everybody that testified in the trial admitted that the DEP is satisfied with what is going on there. So it seems to me they've met their obligations under that guarantee.
But you're saying they're satisfied as long as the property continues to be used as a gas station?
Which was the intended purpose back in 2000, 24 years ago when it was sold. If you look at the change in the zoning laws occurred in 2017. This case was filed in 2018. It seems to me that they're looking to satisfy themselves, meaning the Wallaces, the MARMIK people are looking to satisfy themselves and not the DEP. The DEP is satisfied.
So what's the best evidence that the DEP is satisfied with the current state?
Well, there was no evidence submitted by the MARMIK people that stated that they were issued any notice of noncompliance or anything like that. I would assume that that's what they would have argued. And also the reports submitted by Mr. Peardnock, their LSP, state that they state the option that they had picked and that was ongoing, and that was that. And DEP, they accepted that report. So
No,
by
but
virtue of...
can I just stop you there? Because
Sure.
tell me if I'm wrong, but I know the way the state process used to work is that this would now be handled by the LSPs, and DEP, once that was on track, DEP would get involved only if the site were audited. So there is not actually DEP sign-off on your average contaminated site.
Right, so I guess the answer to the question that I was given is I have to prove a negative, which I can't do.
But isn't your point that these options would satisfy the state cleanup regulations, known as the MCP, and therefore, ipso facto, they would satisfy DEP?
That's exactly correct, yes.
But there's no direct evidence that DEP is satisfied with the state of affairs as they are today.
Again, it would be trying to prove a negative where if they were not satisfied with it.
Direct evidence.
Excuse me?
Direct evidence.
The direct evidence are the reports that were issued to the, or sent to the DEP by the LSP, the MARMIK LSP, and there's no indication they were rejected.
Right, but it seems to me that your argument could get your client out of the frying pan and into the fire. Because if the basis for the department being satisfied is that there's an LSP who's monitoring things, then you would be responsible for the ongoing monitoring. And over time, that seems like that could really be much more pricey than what the judge ruled.
I really don't know the answer to that. However, what the judge ordered is beyond the scope of what is presently going on now. So that's why this appeal has occurred.
Okay.
And so the standard is manifest injustice, is that right?
That's correct.
Oh, the red light has been on for 1 minute and 54 seconds. My colleagues have signaled to me they have no further questions, so we will now hear from Mr. Packer's attorney.
Good afternoon. May it please the Court. Dana Curhan for MARMIK, LLC. I will skip the procedural missteps and go right to the merits. The judge in this case had 4 potential solutions. 3 of them were permanent solutions. One of them has been described as the Band-Aid solution, which involves monitoring. It's our contention that the judge properly rejected that. She said that solution would require that both of the neighbors accept AULs, and one of them was not willing to do that. Also, it doesn't satisfy we contend it doesn't satisfy the plain language of the guarantee, which is pay for a cleanup. There's no cleanup in the monitoring. It's monitored, and if there's a problem, then there may be a cleanup down the road, but it's really academic because because the neighbor won't sign off on it, that solution, that's dead in the water anyway.
Right. Let's assume we agree with you, though. He rightly points out that the court concluded the language was ambiguous, so shouldn't at that point the court have taken the intent of the party's evidence? Or was that a mistake and it's not that the language is ambiguous, it's what would satisfy that language?
I think it may be the latter. It's clear that there's going to be cleanup, and I mean, the problem is that Mr. Packer got his own experts in. And the first one, well, my clients thought that this was...
Are you referring to Mr. Cagle?
I'm sorry?
Are you referring to Mr. Cagle?
Yes, I am. He essentially said, hey, there's no problem here. It's all cleaned up. And...
So why is it a problem that the other fellow got his own experts in?
Well, we eventually got our own expert in.
Oh, okay.
Who said, look, the first expert sort of tried to pull the wool over DEP's eyes. The second expert was superficial. She didn't dig deep enough. She didn't look far enough, and she essentially was pushing, the temporary solution. And then after she had been gone from the site for 2 or 3 years, we got our own expert in. We paid him $102,000. He came up with a solution, with various solutions, and then he testified as to what they entailed.
But doesn't the same argument hold true, that monitoring isn't cleanup, and determining what needs to be cleaned up isn't cleanup?
Well, I think determining what needs to be cleaned up is part of the cleanup. Under the statute and the regulations, we can't just go and say, let's bring a backhoe in next weekend. We have to figure out what the problem is, the extent of the problem.
And you did that, and it cost you $102,000 to get that.
Right, and we also have to propose the solutions, and that's what we did. This is part of the cross appeal, of course.
I understand, but that's all cost of doing business. That's not cleanup.
Well, we contend that it is cleanup because the regulations require it as part of the cleanup. In other words, you can't just, it's not just what is making the property less contaminated. It is, let's figure out what the problem is and what the solutions are. And that is something that, we contend should be recoverable as part of the cost.
You think that these are sophisticated parties who entered into this guarantee?
I think they are very sophisticated parties.
So if they wanted to say, including determining what the cleanup is, they could have said that.
I'm not sure if I'm not sure if they anticipated the extent of. Let me back up for a minute. I think it was the understanding of my clients that Mr. Packer was going to take care of this. And he represented for a while that it was taken care of, and it wasn't. And then when we started getting notices saying that we're not in compliance, that's when we started contacting Mr. Packer. And this went on for a long time. And we finally got our own people in there and said, complied with the regulations. This is what needs to be done in order to clean this property up.
Isn't what you call the cleanup in part to deal with the off-site contamination that resulted from the leaking here?
Certainly. I mean, I think everything is.
And did Packer ever argue that the off-site contamination was not covered by the guarantee at all? This was about addressing any contamination at the site.
I don't think he ever made that argument, and I don't think that argument would have been appropriate in this case because this place has been a gas station for 100 years. We understand that there's there may very well be restrictions placed on our property as a result of that past history. The big problem is that there's an ice cream shop next door and I think a restaurant on the other side, and the contaminants are flowing over to them. And that really is, I think the cleanup solutions focus on preventing the migration of these contaminants to the other properties.
So as to one of those properties, I thought that the contamination was marginal, but is there some, didn't I read in the record that there was a concern that perhaps some of the spill took place since MARMIK owned the property?
There was a spill of gasoline on one portion of the property since MARMIK owned it, and that was taken into account.
When you say was taken into account, what is
that was disclosed to the judge. The parties knew about it. There was, I believe there was some testimony about it at trial, but it was not the significant portion of what we were trying to clean up. I believe there was some cleanup at the time, I'm not sure, but that's not really, the big problem is you have 100 years use as a gas station, and there were tanks that leaked and there were tanks that were changed, and all kinds of things happened to this property, and that's not really I mean, that could have been raised as a defense. It wasn't raised, so I don't think that's significant here.
So the thing that's interesting about this case is your client hasn't actually done the cleanup or hadn't by the time of trial. So if in fact some, technological breakthrough occurred and it only cost them half of what the judge awarded, they understand they'd have to give the money back, right?
That's probably the case. And, this is fairly recent judgment, and, the extent of the cleanup that we're going to do probably depends on how much we're going to get reimbursed. And it wasn't clear until this past year that we were going to get reimbursed at all. And, their solution was, yeah, we'll give you $24,000 for monitoring, and that should take care of the problem. And it doesn't take care of the problem.
Was that going to be $24,000 a year?
I believe $24,000 total. I didn't see that as per year. And, I think it is a temporary solution, and because it's a temporary solution, it may very well be that if some of the monitoring discloses that there's contamination in the adjoining properties, then there may have to be a more extensive cleanup. In other words, one of the three solutions, A, B, or C, and the judge in this case said, okay, I cannot accept the $24,000 Band-Aid solution, but as to the three permanent solutions, I will award you for the least expensive one minus the $35,000. So that's really what we have here. And I think once we collect, we may very well take the first solution and spend the money, but there will at least be some significant contribution.
So there was no counterclaim, correct?
No, I don't believe there was a counterclaim.
But your position, I take it, is that the $105,000 in response costs that you're seeking were subsumed within their complaint?
No, it was our complaint. We're MARMIK. We sued them.
Oh, I'm sorry.
For the cleanup costs. We said the cleanup cost is one of the solutions plus the $102,000, and that's at Record Appendix page 582 where that was argued, and it was also argued in the post-trial motions. Unless there are any further questions, I think I covered both our counterclaim. I'm sorry, both our. I'm getting as confused as you are.
Cross-appeal.
Cross-appeal and the issues on appeal. Unless there's anything else, I'll leave the remaining points of the briefs.
Okay. Thank you both very much. I now twice have misidentified you as the lawyer for Packer. I will stipulate you're the lawyer for MARMIK. Thank you both very much. Interesting matter. The case is submitted, And that concludes our session today. Our thanks to the court officers and to our technical staff and the law clerks, and we are adjourned.
Thank you, Your Honor.